Here, the Court of Appeals of the State of Michigan is now in session. Honorable Thomas C. Cameron, the Honorable Michelle M. Rick, and presiding the Honorable Michael F. Gadolo. All persons having business herein draw near, give attention, and they shall be heard. That say the United States, State of Michigan. Please.
Good morning. All right, well done. Welcome to the Michigan Court of Appeals. On behalf of my colleagues, Judges Cameron and Rick, this is panel 4 in Detroit. I'll give the attorneys my usual advice or admonitions. We are familiar with all the cases on the docket today. Of course, we've read your briefs. We have reports from our staff on all these cases, so you don't need to belabor the facts. Just cut right to the most salient and decisive legal issues and let us know as succinctly as possible why you should prevail in your appeal today. In cases involving minor children or protected individuals, initials only, please, no proper names. These proceedings are being taped and will be uploaded to YouTube within the next 24 hours. So with that, I think I can proceed to call our first item of today, which was originally to be argued tomorrow. But so we're starting with item number 26, docket number 372-863, Sierra Chantel Phillips versus Deontez Johnson. Mr. Gentry.
Good morning, Your Honors. Kevin Gentry on behalf of the appellant. Justice strives to be blind because it's the merits of the case rather than the agreeability of the parties that's supposed to matter. And it's real hard with improper clients, Your Honors. It is one of the hardest things the judge has to do is deal with unrepresented parties who have no idea what they're doing. It's stressful, it's difficult, and it's bad for everybody involved, including the record. However, that doesn't mean that they don't get the basic rights. And that is really what we have here is we've got 3 substantial mistakes. I'm not going to focus on issue 3 at all. In this case, I'll leave it for the briefing. But the first thing, my client was the plaintiff. The defendant got an opening argument. She tried and was told, I only take testimony by the trial court. That's not good. And then the defendant started with the case and started cross-examining my client as my client never presented her case until backwards. The trial court has authority as far as the order and manner of witnesses and stuff like that, but there's some really basic due process things that are missing here. And the biggest one is the cross-examination. On pages 144 and 145, after the defendant's wife testifies, the trial court says to my client, do you have any questions? And she says, yes, I have questions. On what? Everything she just said. What are they? I'm not sure I'm going to allow them. We need to get this finished at this point. Pages 144 and 145. Your Honor, there's a gajillion reasons to not allow a question on cross-examination. They're called the rules of evidence. Question, objection, ruling.
Mr. Gentry, after that portion that you just read from the transcript, the judge again asked, what are your questions?
And she said,
your client basically said, never mind. She didn't. So what more was the judge to do with respect to that issue?
Your Honors, I have 30 minutes up here. And if Your Honors tell me I have enough, I'm going to sit down because the court controls the courtroom, not the client. And an unrepresented party, when the judge asks her something, is going to yield to the judge's ruling. And I think that's really what happened here. Cross-examination, if I have to show all my cards on cross-examination before I start the case, I'm not going to start, Your Honors, because as any lawyer knows, cross-examination is not about showing your cards. That's what a deposition's for. 722.273, clear and convincing evidence of harm on parenting time, physical, emotional, or mental health. There's no question the trial court did the best interest factors. No question the trial court found clear and convincing evidence on custody. I agree. And remember, the defendant said, well, my client never wanted custody. Read the complaint for custody and parenting time. And there's no finding on physical, emotional, or mental health or health endangerment here. There's got to be a clear and convincing finding to deny parenting time. To go to zero, there has to be a finding of something. And there wasn't here. And you know what really controlled this case? What really controlled this case was the agreement. My client signed a really bad agreement she should have never signed. But you know why it was a really bad agreement? Not because it was bad for her, because it's void against public policy. Under TUR, a client can't say, I'm giving you the kid and walking away from my child support responsibilities. That's violated of Michigan law. That's violated of public policy. The trial court at the very least should not have considered that agreement and should have recognized that for what it is. This trial court knows what it's doing, Your Honor. We all know who it was. But people get stressed. People get angry, and my client can make people angry. But the reality of the situation is she didn't get what she came to court for, and that was a fair hearing. Thank you, Your Honor.
Any questions for Mr. Gentry before I let you sit down?
One question.
Judge Cameron.
In terms of the agreement that your client signed, how would you have written that agreement to be lawful?
To be lawful, Your Honor, it would have said that somebody's going to have custody, I'm not going to have parenting time, and we're going to follow the MCSF. I don't think you can do anything else.
Our parenting time agreed to as agreed to. by
Parenting time
parties.
agreed to would have been fine. That would have been fine. I'm not even sure my client can give away all of her parenting time. Maybe she can. I mean, Hodge says consenting adults can do a lot of things,
Right.
but they can't take away a child's right to entitlement to support from both parties.
Okay, thank you.
Thank you, Your Honors.
Thank you. You'll have time for a rebuttal. Ms. Whitman.
Morning. May it please the court. I first wanted to say thank you very much for accommodating my
Oh, sure.
schedule and brother counsel as well. I really appreciate
You
it.
have to drive here in this lovely weather.
Yeah,
too.
and now I have to drive to the airport, so that'll be more fun.
Give us your appearance first.
Beth Whitman appearing on behalf of the defendant in this case. The concern here is really that brother counsel has indicated was really with the timing of the way that the evidence came in. There's no question based upon the record that the court asked Ms. Phillips questions, allowed her to answer all of those questions fully, asked her at the end of the questioning, do you have anything else that you want this court to know? And allowed her that opportunity to say what she wanted to say. The fact that she wasn't able, I agree with you. I think that the issue with respect to the cross-examination, I think that was waived by her by saying, never mind, go ahead. But also in the brief, she indicates this is what I wanted to ask. I wanted to ask her Ms. Johnson questions regarding her statements about how civil things are between the two of us. Well, the problem with that is that it's wholly irrelevant to the issues in this case, which is the best interest of the child factors. And also, it's not something that the trial court relied upon. The trial court didn't say this is in the best interest of the child because there's this civility that occurs. It just wasn't one of the factors that she looked at. What's important here is that she did look at the factors, which were the child has been with Mr. Johnson and Ms. Johnson since birth, does not know that Ms. Phillips is even his mother, and that even Ms. Phillips admitted during the evidentiary hearing that it'd be extremely traumatic for this child to learn that she is in fact his mother, and that the people who have raised him since birth are not in fact his parents. With respect to the agreement, again, you look at what was going on at the time. She was looking into possibly giving this child up for adoption. Mr. Johnson came in and said, I want this, I will take this child, I will love this child, I will raise this child, and I will do this with my wife. And that's exactly what they did. This doesn't go against public policy for the mere fact that it doesn't prohibit the child from getting care and treatment or the support. Thank you. Not treatment, but support from either party. She just didn't want to be part of this child's life. And that's exactly what the party said.
That might be a different situation if this were the normal case in which we see this issue arise. If your client was seeking support from his client.
Exactly.
That's
Yes.
not the case.
That's
here,
not
is
the
it?
case here. So, if he were to say, I want support from you, and
Yeah.
she said, no,
Oh,
we
I
have this
contracted
agreement,
away.
that is exactly what the case
We
law.
wouldn't recognize that.
That's exactly
right?
it. That goes against public policy.
Should it matter that that's not happening here? I mean, the agreement is the same.
It's the same, but it's not, the question that is in the case law is whether the agreement acts as a bar to a claim that's for the benefit of
Right.
the child. So here, that's not what we have. This, again, the trial court found the agreement, the status quo of what they had was in fact in the best interest of the child.
Any questions? Okay.
Okay.
Thank you.
Thank you
Mr.
very
Gentry,
much.
anything more?
Your Honors. First off, the trial court relied on that agreement for best interest findings. Factor J, because Ms. Phillips executed the agreement regarding custody, parenting time, and support in which she relinquishing custodial parenting time relationship she had with insert child's name. And Mr. Johnson, therefore, he had no obligation or requirement to encourage any relationship with insert child's name. And it would be contrary to that agreement as well as his raising of insert child's name with his wife, which Ms. Phillips testified she knew he was going to do. It would be contrary to that understanding. The court is using this agreement, which is void against public policy, to make best interest findings. There's a problem with that somewhere. There's a problem with that somewhere here. And the court isn't fulfilling its statutory responsibilities. Maybe on remand, they may. I mean, my client admits it's not going to be good for the child. Is it going to be harmful? I don't know. Maybe on remand, the judge could find that. But she didn't find that here, and the statute requires her to do that. And that just didn't happen, Your Honors. Thank you.
Okay, thank you very much. Appreciate your arguments and for appearing here in person today under the circumstances. Case is submitted. Thank you. All right. Now that brings us to item 1. Docket number 374998, People of the State of Michigan versus Dwayne Eugene Howell. And counsel for the appellant, Ms. Palmer, has waived due to illness. And counsel for the appellee, Ms. Woods, is endorsed. Good morning. You may step to the lectern and give us your appearance and proceed.
Yes, thank you. Good morning, Arlene Woods, appearing on behalf of the appellee, Dwayne Howell. And I'm sorry for the way I sound. I've been fighting a cold for 2 weeks.
No problem.
I'll be brief, Your Honors, because I think the only issue here is whether after repeated attempts to get the prosecution to comply with discovery, Judge Evans finally dismissed some of the evidence, not all of the evidence. So the only issue is whether she abused her discretion, and I would submit that she did not. There had been 7 or 8 prosecutors on this case, and I've lost count because we're now up to about 9 or 10, and 3 judges. 3 judges had ordered this discovery. Judge Evans had ordered it repeatedly. When they finally gave me the discovery, it was tantamount to having the court order them to return my vehicle. And the prosecution said, okay, Arlene, your vehicle's sitting out there in the parking lot, but they don't give me the keys. So they haven't returned my vehicle. That's what they did with this discovery.
I'm sorry. I stepped on your toes. Did you want to say anything else before I ask my question?
No, I was just going to say, when they finally gave us the discovery that they had been ordered repeatedly to give, they left out an essential reader for us to be able to retrieve that data and go through it. Without that reader, we didn't have any discovery.
My question went to the September 12th order, and that I thought the requirement was the prosecutor would provide a copy of the information and put that on the external hard drive by date certain. I mean, didn't that in fact happen?
Yes and no.
Okay, tell me about the no part then.
Yes and no, because that was what I was saying about giving me my car back without the keys. There was an essential reader that had to go with that external hard drive to be able to open those documents and retrieve them and be able to read them. And without that essential piece, without that essential reader, it was tantamount to not giving us the discovery.
Why did it take you 5 months to figure out that you didn't have the keys to the car?
Well, it didn't quite, Your Honor, because maybe it didn't come through in my brief. I was trying to work with the officer in charge, Mr. Stegler, and I told him, and I think I made mention of that in my brief, I told him, hey, there's something missing. We can't open this stuff. And it's constantly, we'll get back with you, we'll get back with you, we'll get back with you. I was trying to work with them and not keep running into court in front of Judge Evans with motions. Mm-hmm. And once it became apparent, and they were just basically blowing me off, and Mr. Stegler even Detective Stegler even stopped returning my phone calls. That's when I took them back to court. So it may have seemed as though I might have been somewhat dilatory, but as I've indicated, I was trying to work with them and not just keep running to the court, bringing motions.
Okay.
So I don't think that the judge abused her discretion at all. They were given ample opportunity to turn this stuff off. Over 3 judges had ordered them to do it. And I think, and just as an aside, and again, I don't know if I made it really clear in my brief, but this evidence that Judge Evans struck is not really even essential to their case. The phone dump and the dump from the computer unit is not really relevant to their case. I mean, yeah, we can go through all these documents and an expert can say, well, you know, the vehicle moved this many miles an hour and was in this vicinity. But the essential thing here, no one, not one witness ever indicated that they ever saw a car that was ever tied to Mr. Howell at that location of the shooting. So getting the CEU unit off of the vehicle is not relevant to anything because his car was never identified as having been there.
Can you
This-
help me with the CUE data in particular? And I think this is something the trial court did that I think even you might concede may have been in error, because there's a distinction between the CUE data and the phone records. And it's the latter set of records where maybe the keys to the car hadn't been provided as they should have been. But Judge Evans excluded the CUE data apparently on the basis that it hadn't been produced, when in fact it had been produced, but she excluded it nonetheless. Am I correct in that understanding?
Some of it had been produced, Your Honor. There was a printout from the data back that they took out back in November
Mhm.
of, I believe, 2023. But there was some additional information from that CEU unit that was supposedly on that hard drive. But since I could never open the hard drive, I don't know whether it was or not. So yes, there was some initial documents given that they pulled off the hard drive, off of the car, but there was still more supposedly that was on that hard drive.
Okay. Thank you.
So it sounds like potentially there could be some evidence that would exonerate or bolster your client's, case. And it, in my mind, begs the question, so why not let it in?
Well, here's the problem, Your Honor. They tore that CEU unit up. They had to go back. They got a warrant to go into the CEU unit. Then they had to go back and get another warrant allowing them basically to damage the CEU unit if they needed to get the data, but they had already damaged it. So that's torn up. The phones were destroyed as they extracted the data. So when the prosecutor says, well, Ms. Woods could have got her own expert. My expert for what? If I wanted to have an expert at this point to contradict or to explain away any information, go back in and compare the information and see if there are any errors, we're precluded from doing that now because they tore those things up. They're destroyed. They're no good to anybody at this point. So when you say it would be good to let it in, at this point, it would be prejudicial to Mr. Howell because I can't even get an expert to look at the data and say, no, this isn't correct. Nope, they didn't interpret this correctly, Arlene, because they tore up the phones and they tore up the CEU unit.
Do you know, Ms. Woods, how it is that occurred? I don't think I've ever seen this circumstance where in the process of extracting data from a device, the authorities, as you put it, destroy the device. I mean, they didn't take a hammer to the devices. What happened and why?
I don't know exactly, but what I was able, just on my own, to somewhat glean, based on the 2 search warrants that they had to get. The first one to go in, and then the second one that said, okay, if you have to tear it up to get the data, you can do that. What I gleaned, from my limited knowledge,
Understood. We're lawyers.
they had trouble getting, first of all, trouble getting the CEU unit out of the vehicle.
Mm-hmm.
And once they got it out of the vehicle, they had probably already done some damage to it, trying to get it out.
Okay.
And then trying to retrieve the data off of it, they had to do more damage to it.
Okay.
But that's just my guess, Your Honor, because here again, I can't even have an expert look at it and say, oh, here's what happened, Darlene. Here's how it got torn up.
How-
Because they tore it up.
How is this different than if you had a DNA sample that was very, very small? And in the course of analyzing that DNA sample, you consume the sample. There is no sample left because the sample size is so small, it is consumed as in part of the test. So in terms of an expert, if that was the case you were dealing with, you'd have to hire an expert to take a look at the DNA profile, look at the different markers and whether it matches in the way the prosecution alleges it does. Why can't you do that in hiring an expert at looking at the data and say whether it's corrupted or not, or whether the assumptions the prosecution's making is correct or not?
Well, if I may, and I think I understand your question. There's two things, Your Honor. There's looking at the data, which, as I've indicated, they didn't give me the keys to the car to look at the data. And then there is looking at the car, so to speak. I can't look at the car now because they tore it up. In your example, they could go through and look at all the DNA markers. That's a little different than this case because this is a physical piece of evidence that we now don't have an opportunity to go through. And at this point, to allow any of that data to come in, I would submit would be very prejudicial to Mr. Howell because we have no way to determine whether the data was correctly extracted, whether it was correctly interpreted once it was extracted, because we don't have the physical piece of evidence.
Okay. Any other questions? Anything else for us, Ms. Woods?
No, thank you for your time.
Thank you, Ms. Woods. That was well argued. Thank you.
I hope you find your voice.
Yes. We appreciate it. And the case is submitted.
Mhm.
Okay, that brings us to item number 2, I believe. Docket number 372141, People of the State of Michigan versus Claudina Yvonne Dorset or Dorset. And counsel for the appellant, Ms. Morgan, has 10 minutes of argument time.
Morning. May it please the court, I'm Joan Morgan. I'm here for Miss Dorset. This was a jury trial in Oakland County Circuit Court, which resulted from a very acrimonious breakup between the complaining witness, Tadaro Griffin, and my client, Miss Dorset. The issue at trial was that Mr. Griffin had apparently purchased a truck to form a trucking business from a cousin of his. And after the date of the purchase, which I believe was established as May 1st, 2022 on the record, my client put the title to the truck in her name and then executed some other documents with the Secretary of State. 2 witnesses at the trial, Mr. Griffin and an investigating officer, Detective Mounts, M-O-U-N-T-Z, from the Oakland County Sheriff's Department, both testified against my client's theory of defense, which was that he had a legitimate license to purchase the truck and to drive the truck. Whereas my client testified that the reason that she put the truck title in her own name was because Mr. Griffin's license was not valid. And this became a contentious issue at trial. What happened after I was appointed to represent Ms. Dorset is that I obtained certified copies of Mr. Griffin's driver's license from the Secretary of State and submitted those with a motion for an evidentiary hearing to the circuit court judge, who denied the motion for a hearing on the grounds that it was untimely. I don't believe it was untimely, but in any event, I was not able to establish
Well, whether it was or was not untimely, he had a valid driver's license. It was restricted, not suspended. He had the privilege of driving, didn't he?
I don't, well, he had a
Under the records that you submitted.
yeah, he had a restricted non-commercial license, but his license was not eligible for a commercial license permit. And that's another,
Why does that matter?
in my opinion, it matters because that would have shown that Mr. Griffin could not have purchased the business, and it would have supported my client's theory that was the reason that she put the title to the vehicle in her name as
Well,
opposed.
did she
to
have a
his.
CDL? I don't think so.
She did not.
Okay.
She had a valid driver's license, but she did not have a CDL.
As did he. I think probably you're better served moving on to the restitution.
Restitution. So let me say this, if I can, about the restitution. My position in terms of the restitution is that the order that the trial court entered resulted in what I would call in the vernacular double dipping to Mr. Griffin. It compensated, and I use that word in air quotes, but it compensated him both for the purchase price of the vehicle as well as storage of the vehicle. And then in a kind of loosey-goosey determination of what repairs might have cost, because the testimony from the witness who talked about what repairs might have cost had a very broad range of expenses that could be incurred. I think that may have been partially because he hadn't actually seen the truck, but Mr. Griffin was, under this order, compensated for both the purchase price of the truck and for the repairs to the truck. And it's my position.
As well as the truck itself being returned to him,
I'm sorry.
right?
Yes.
Yeah.
And I think that's impermissible. I don't think under either of the restitution statutes that I cited in my brief that he can be compensated for both. I think the case, my request to the court would be that you order that the repairs not be allowed. And simply if you're going to affirm the other parts of the restitution order, that you do so for what we know were actual expenses, and that would be the purchase price of the
Well, let
truck.
me ask what I think is a more maybe fundamental question. The
Mhm.
statute requires that the trial judge first determine that the return of the truck itself, in and of itself, was quote unquote, I'll use the air quotes, inadequate.
Mhm.
Did the trial court ever make such a determination?
I don't believe so.
I don't either.
No.
Okay.
Yeah.
Any other questions for
No.
counsel? Okay, you'll
Thank
have
you.
time for rebuttal.
Okay, thank you.
Good morning, Your Honors, and may it please the court. Joshua Miller from the Oakland County Prosecutor's Office Appellate Division on behalf of the people. We are asking the court to affirm the conviction as well as the restitution order. I will rest on my brief as to the issue of the alleged false testimony, because I think the court's questions indicate that the court does understand that issue, so unless there are any specific questions for me on that. Moving to the restitution issue. The focus of restitution is always on what did the victim lose? What were the losses? In this case, I think there's no dispute that there were losses incurred because the truck had to be stored for 2 years, unusable because of the defendant's criminal conduct. The repair costs, to answer a question, preemptively answer a question that Judge Goodall had posed to opposing counsel. I think that the court's determination that repairs were necessary was at least an implicit finding that the return of the truck was inadequate, because you have, we all have lived in Michigan for a very long time. We see these semi trucks on the road. We know that they are constantly running. And so when you have one of these trucks that sits completely immobile for 2 years, it's going to deteriorate. And under the Matsky case, which is cited in my brief, 303 Mishap 281, that was a case where you also had an instance where the repair estimate was accepted by the court as as a loss. And so I think when you have a professional who's evaluating what condition this truck is in and what's necessary to get it back and road ready under Department of Transportation regulations, I think that is an acceptable estimate.
But the judge here awarded far more than that, didn't he? It wasn't just the repair costs. It was the return of the truck and the repair costs, and then almost like replacement value of the truck.
Because Your Honor, when the truck was returned, Mr. Tadaro Griffin had also been making payments on this and a second truck for 2 years, but he couldn't use them. So I will concede, as I do in my brief, that ordinarily those would be, if he's making installment payments on this truck, that would be a cost of his business, absolutely. And so that would not be something that could be compensated. However, we have an instance where the costs are transformed into a loss because he's trying to run his business with his second truck, which he ended up having to sell because he couldn't make his business work without this first truck. So he's making these payments, losing money consistently while he's waiting to try to get the title and the keys to this truck back. And so I think that transforms this into something different than just returning the truck and giving the replacement value.
If this would be a case where you have a $50,000 truck, 2 years go by, and that $50,000 truck, not because it's immobilized or not because the tires are rotten, nothing like that, but it was a $50,000 truck. Now it's a $30,000 truck because we all know the longer you have a vehicle, it depreciates. If we were talking about depreciation, would the defendant owe depreciation?
I don't think she would, Your Honor.
That is, you see what I'm struggling with because you have, so depreciation doesn't count, but just the time a vehicle is immobilized in a tow yard to get it back up to whatever condition, which I'm still not clear about, I think $16,000 truck when it was purchased, right?
Yes.
I don't know what kind of shape. I don't know. It strikes me that $16,000 for a semi is pretty cheap. I don't know if that's true or not, but I don't know what kind of condition it was in. And certainly we don't want the individual to be rewarded by having a better truck than he bought through restitution. So if depreciation doesn't count, why do the repairs just through time? Not because the victim slashed tires or broke a mirror off, just the passing of time is something that the defendant should have to reimburse the victim for.
Well, if it was ordinary depreciation, Your Honor, I do agree. It would be a very different instance because the immobilization in this case, the deterioration in this case, was directly caused by the defendant's actions. So ordinary depreciation wouldn't result from the defendant taking some action, but the immobilization did. Mr. Griffin didn't have the title to the truck. He didn't have the keys to the truck. He couldn't even start the truck. Perhaps if they had even had the keys and they could have at least turned it on and run it, that might have staved off some of the deterioration, but he couldn't even do that. So I think that sets this apart from just an ordinary passage of time depreciation.
Okay. Anything else? All right.
Thank you
very much. Any rebuttal?
Make clear that this wasn't an issue of actually returning the truck. The truck was always in Mr. Griffin's possession. He had somehow moved it to a storage lot where the truck was for the past couple of years. There was nothing that indicated that he was unable to move the truck or anything else. And apparently his financial situation was such that he could not make any repairs that needed to be made to the truck. But he bought the truck, again, as Your Honor said, for what appears to be a very low price. And apparently he purchased it from his cousin. So I'm assuming that he had some knowledge as to what the condition of the truck was. the final thing I would say is that in terms of recommendations, at the restitution hearing, probation also recommended that he be awarded only the purchase price of the truck, and the judge did not follow that recommendation. I don't have anything else unless
Anything
you
else?
do.
Nope, thank you.
All right, thank you very much.
Thank you.
Appreciate your appearances here today and appreciate your arguments and the cases submitted. Okay, that brings us to item number 3, docket number 372130, People of the State of Michigan versus Anthony Lee Parrish. All right, Ms. Labreck is appearing via Zoom. Counsel for the appellee is present here in the courtroom. So you can give us your appearance and proceed.
Good morning, your honors. May it please the court, attorney Ann M. Lebrecht appearing on behalf of the defendant. For the most part, I will rely on my brief with a brief statement that in the 20 plus years of being a lawyer, not that I'm saying that I'm better than anybody else, but I'm just stating my own personal observations. Mental health is frequently the underlying issue on many of the cases that I represent clients in, to the point that it's endemic. When I speak to my clients, I find out frequently that many of the situations that they get into as far as substance abuse, as far as contact with criminal law and things of that nature, is due to underlying issues. Obviously, the court is not able to, wave a magic wand and fix these things, nor are they able to create public policy. But it's one of the things that I think needs to be considered. I don't know what the solution is, your honors. I wish I did, but it's something I see frequently, which is why I argue these particular issues. A lot of times these people will, with mental health issues, they will get treatment, and the underlying medical issues are treated with medications that don't make them feel well. So I'm not sure whether or not, that was the situation 100% in this case, but I do see it frequently, and I wanted to bring it to the court's attention. Thank you.
Counsel, if I may, I noticed that your client was considered for mental health court and was declined admissibility. And I think that, if I'm not mistaken, your district court judge, so it's the district court judge who presides over mental health court. This obviously involves the circuit court. So, I mean, that judge didn't find your client to be a good fit for whatever reason. So it begs the question, when we're looking at a sentence within guidelines, how are you able to rebut the presumption that it's an appropriate sentence? I understand what you're saying about mental health.
Well, I think some of it, it is esoteric. Lawyers and judges were not psychologists or psychiatrists. So, how can somebody make that determination as far as whether somebody's appropriate or not appropriate? I understand my client's history as far as going to these things that were ordered by the court weren't exactly stellar. And
if I can push back a little bit, though, it isn't that just the judge sits there and says yes, no. They have an entire team, which typically includes mental health providers, social services, and a host of other people who would be in tune and probably better able to make those determinations. So I don't know if I will accept that statement wholesale, but again, I hear what you're saying.
Correct. And I think some of it is too that depending on, these are individuals, not saying that they're biased, but these are individuals usually brought on by the court system themselves. So there's different viewpoints, I think, versus somebody that would be independent, evaluating a client for things like this. So that, I think, is something else that needs to be taken into consideration. And I'm implying that, probation officers, mental health officers are in any way biased. I in Eaton County back in the day was one of the lawyers on a panel for the drug court in Eaton County. And I don't think those folks are biased either. So, I mean, I have some, familiarity with those types of courts. I just think that when people need help, instead of having a repeat customer come back, more or less, I guess, for lack of a better way to put it, if they have these issues, why not attempt to fix them so we don't have them come back?
Thank you.
Okay, thank you very much. You'll have time left for rebuttal. Council.
Thank you, Your Honor.
Good morning, Eric Hinojosa on behalf of the people, P76546 on behalf of the Tuscola County Prosecutor's Office. I don't believe that there's anything unusual really about this case that would compel this court to find that the trial court abuses discretion in sentencing within the guidelines. The fact that the defendant suffers from mental health issues and experienced trauma in his life is unfortunately not unique and something that our courts deal with every day. Is something that is taken into account when sentences are handed down as part of the PSI. His poor decisions to medicate his mental health issues with illicit drugs, also not an uncommon thing, something that trial courts across the state see every day. Something that I believe that our court considered in handing down the sentence that she did. His choice not to benefit from the rehabilitative opportunities that were presented to him that were discussed within the PSI is also not, unfortunately, unique or mitigating in this case. Doesn't warrant discarding the framework that's set forth by the guidelines. I don't know for sure what led to his denial by the mental health court in our county, but I would suspect that if I'm considering him for mental health court services, his repeated failure to comply with prior provisions of services suggests that he's not going to succeed in that environment. It's a very intense environment. There's lots of requirements put on these individuals, and you have to be willing to step up and do them. And he's not been willing to do that in the past. I think we can reasonably discern that he's probably not going to do so in the future. So I don't think that there was anything special about this case that would warrant a finding that the within guideline sentence that was imposed was disproportionate in some way. Thank you.
Any questions?
No.
All right. Thank you very much. Any rebuttal, Ms. Lebrec?
Just briefly, while situations like this are not unique, the individuals involved are. And with that, I will rest on the rest of my brief.
All right. Thank you very much. Appreciate your arguments here today, and the case is submitted. Mr. Hinojosa, you can just switch tables because you're up next in item 4, docket number 372747, People of the State of Michigan versus Damian Gerard Isidoric.
Eric Hinojosa on behalf of the people. As the court is well aware from our brief, there have been a couple of cases recently that in Tuscola County where this court has found that our trial court has improperly decided to dismiss criminal cases with prejudice. In each of those cases, the court has recognized that a circuit court's authority over the prosecutor's discharge of their duties is limited to activities or decisions that are unconstitutional, illegal, or ultra vires, and reverse the trial court.
I think I was on one of those prior appeals, and this particular trial judge has been reversed twice, and another judge within the circuit a third time on essentially this very same issue. So there seems to be a proclivity for this sort of thing, despite our repeated efforts to correct the error.
Yes, your admonishments have been cited to the court and have not been heeded.
Right.
So, I mean,
So let me ask this, if I may, if this panel were to act favorably on the matter before us, which is purely hypothetical at this point, would we need to retain jurisdiction to ensure that there was compliance with?
I would hope not, but if that is something that the court believes might induce the trial court to listen to your admonishments, I would be in favor of it.
I'm hearing that there is somewhat a track record, which is why I'm asking the question.
Okay, I appreciate that.
In the other cases, did the trial court reinstate the case?
I believe in.
If the trial court didn't, would you have appealed?
We would have appealed.
Have you appealed?
I think so one of them was a special prosecutor case, as I recall, out of with the Genesee County Prosecutor's Office coming into Tuscola County to deal with that case. And I don't know that. I'm not intimately familiar with that one. As far as what happened in Mr. Plain's case, that case was reauthorized with the correct charges and ultimately pled out as it should have the first time. And then I believe let's see, it was Wilson, Plain, and the other case is slipping my mind. I apologize. But yes, I believe all of those cases ended up resolving as they should have after they were sent back to the trial court. But ultimately, I mean, in this case, again, there was nothing that was, I think, unconstitutional, illegal, or ultra vires here. We were surprised by the court's decision after telling us at the status conference that this particular case would go to trial on Thursday because there was another case preceding that would go on the Tuesday. We relied on that. And then ultimately, when unexpectedly the case that was set for the Tuesday pled out, and it was truly not expected from anybody because
Even the trial judge didn't expect it.
Yeah.
She even said in the status conference, there's no way he's going to plead. I mean, he succeeded on appeal and getting the case for plea withdrawal.
Yeah.
We had the case sent back.
We've been tussling with him for 2 years at that point, and he steadfastly refused to plea. And then the morning of his, I think the MDOC brought him in. His defense attorney found out that he wanted to plea, communicated that to the trial court staff, communicated that to my boss, and ultimately that plea was then taken that morning to the most severe charges in his information.
Yeah, the three cases are People v. Perry, People v. Plain, People v. Novosad, and I think it's Novosad that I sat on.
Yeah.
Does this trial judge have any requirement that parties appear like a final settlement conference? Because it seems like accepting the plea when you have a jury, that might be a pain point, but perhaps one that could be avoided.
I think the status conference was supposed to be kind of the final opportunity to plea there. And ultimately, I think we started with 20 cases on for that day. I think we'd winnowed it to 6 by the time of the status conference. We came out of the status conferences with, I think, one that adjourned and multiple others that had pled at the status conference. So we ended up with the 2 that were set for the final week. So there was an opportunity to try to resolve that. Mr. Watkins did not avail himself of that the preceding week, but decided to avail himself of that the morning trial.
I mean, I understand, and as I'm sure you do, that when you have a jury, a pool of the, constituency and electorate and people who are perhaps of modest means, who've had to take time off from work, and there is certainly that consideration, but it sounds like the plea that happened unexpectedly was beyond anyone's control and certainly was not a result of any action taken by your office.
It wasn't anything where we suddenly sweetened the pot for him at the last minute or anything of that sort. It was plead to the two most severe charges, as I recall, that he was charged with, and dismiss the remaining, and he accepted that. And that, I believe, was the same offer that had been previously extended. He just had a change of heart when his feet were finally held to the fire. So,
anything else for us?
On that issue, no. I think the second issue, the brief, I could stand on my brief there. There is no statutory authority. There's no court rule authority, I believe, that would allow the assessment of the cost of the jury to the prosecutions in this case. And also there was, even if you were to consider it as a potential contempt sanction, I don't think anything we did was in contempt of the court. We were surprised by the situation. We acted what I thought was in a very reasonable manner, given the circumstances that were presented to us. And we were assessed the jury fees as a result, and I don't believe that was proper.
Well, the chief assistant, now the prosecutor, even offered to go ahead and select the jury for this case on that Tuesday morning with the assembled jurors there, and then begin the trial as previously understood on Thursday. Or the trial judge could have explored whether you could have gotten the witnesses there the next day, Wednesday, right? But that was never explored either, was it?
No, I don't believe so. And I think, had we had a moment to go out in the hallway and start making some calls.
Right.
We could have tried to see that, but we were told, basically, we're proceeding, you're dismissing, make a call right now without further opportunity to consult. And after, and then what you saw what happened in the transcript with the judge basically demeaning my office in front of the entire jury from here.
Right. Okay. Any other questions? You'll have time for rebuttal. Counsel?
May it please the court, Brian K. Elder appearing on behalf of Damian Isidoric. Good morning.
Good
Good
morning.
morning. My client and I take no position as to issue number 2. I am a court-appointed counsel for Mr. Isidoric, and I feel that's outside of the scope of my duties. And so I'll just directly address issue number 1.
Okay.
And the court has already touched upon this. This issue has come up before this trial court in the past, but this particular case is different than the previous cases. In this particular case, and we believe it's very clear in the transcript, my client and I had a status conference on the Friday before these events took place on the Tuesday.
Mm-hmm.
And in that status conference, we had indicated we were going to go to trial. The judge was very clear that we were going to be the number 2 case on the trial docket that day. There was a case that was ahead of us, primarily because that defendant was incarcerated. As it turns out, Mr. Watkins is also a previous client of mine from Tuscola County, so I was generally aware of that case as well. He was going to trial because I had been able to get his case dismissed previously. We knew what our marching orders were, and a trial court has inherent power to tell the parties when to show up and when to be ready to go, and that is what Judge Gerhardt did.
Does she have authority to dismiss criminal prosecutions with prejudice because of a misunderstanding over the trial date?
If the government has violated the Constitution, state law, and its scheduling order, yes. I think that this is the unique situation in which the government has done all 3 things and therefore very clearly acted.
It violated the Constitution because it interpreted the judge's words in a status conference in a different case, granted, on that same Friday. We're starting Isidoric on Thursday. That's what she said. In that, and tell the other lawyer who's not here, we're starting it on Thursday, which is what happened. It was a misunderstanding. That's a violation of the Constitution to call your witnesses up and say, be here Thursday.
My clients certainly have the right to go to trial on the day that the trial court indicates. And once those witnesses are listed, they become the witnesses of the defense. The government told my client's witnesses not to come.
You obtained a couple of adjournments from this trial court, didn't you?
Oh, certainly did.
Yeah. So this is going to be a 2-day delay at most.
If the court had decided, go ahead, you can start the jury trial, jury selection and start 2 days, that would have been in the court's discretion. It's also true that we all knew about this at 8:20 a.m. on that Tuesday, and the government could have gone and got their witnesses.
She didn't give them a chance.
They didn't need her permission. They were told they were the number 1 trial and they could have started.
Yeah, and she said, we'll start on Thursday.
I understand this court's position, especially because the issue has been brought up before.
Yeah, I think we're getting tired of it with this judge, to be honest with you. I am.
I can appreciate that. I can appreciate that. And I certainly will not belabor the point. Well, what I will say very simply is that this particular case is significantly different than the previous cases because of the violation of the notice to appear, because of, and what I think is very clear in our brief through the transcripts, the ongoing management issues between the judge and the prosecutor's office at that time.
Okay.
Be happy to answer any questions the court might have.
Any other questions for counsel? Okay.
Thank you.
Any rebuttal, Mr. Higgins?
No, I stand on the prior.
All right. Wise choice. Thank you very much. Appreciate your arguments and for appearing here today. We do appreciate it. And the case is submitted.
Thanks.
Okay, that brings us to item 5. Docket number 373296, People of the State of Michigan versus Douglas Henry Thomas.
Good morning, and may it please the court, Jonathan Simon on behalf of Mr. Toms.
This case involves a situation where the complainant resided in the family home, and there are allegations of first, second degree criminal sexual conduct, as well as child abuse and indecent exposure between the ages of, allegedly between the ages of 5 and 13. Complainant remained in the family home until approximately the age of 18, at which time she moved in with her boyfriend and his mother. And with the encouragement of her boyfriend and her boyfriend's mother, these charges took place. These charges were leveled. These charges were brought against my client. And
You have to admit, I mean, I could see this being serious round the kitchen table talk. These are bizarre facts. Flea checks that allegedly, and I get that, but flea checks that allegedly turn into inappropriate, illegal, sexual misconduct. Again, I get that's the allegation that was levied, but I don't know that why is that unusual that it's after she's out of the home and she's an adult and this bizarre flea check thing happened? I mean, why is that problematic?
well, whether it's flea check, bed bug check, what's disturbing is that in order to substantiate one count of CSC1, one count of CSC2, 50 or more episodes of these checks, flea checks, bed bug checks, are brought in as other acts evidence. And not simply as 404B to show a specific reason, but more under 768.27A, they were brought in as propensity evidence. And so in order to substantiate two allegations, in essence. Well, I suppose the prosecutor could have brought 50 counts, but they didn't. So because they only brought, I guess, two with respect to this conduct, the flea bed bug checks, the other incidents aren't admissible under the statute. Why should that be? I don't know why the charges were resulted as they did, and perhaps you're right, maybe 50 more counts could have been added. But then again, maybe the evidence showed that there wasn't sufficient evidence to prove beyond a reasonable doubt these so-called flea checks or bed bug checks, and they were just added in as window dressing in order to prejudice Mr. Toms in terms of the allegations, these delayed allegations that were made maybe 5 or more years later. So why specifically were they not admissible, in your opinion, under the statute, which is how they were admitted? Because we believe that the probative value was substantially outweighed by the prejudicial effect. All right. So we believe, and this was a case where I think the jury was somewhat torn because they did find Mr. Toms not guilty of the indecent exposure. So they did have some doubts about the case, and bringing in 50 of these allegations in order to substantiate the 3 that he was convicted of, I think was far more necessary than, far more prejudicial than I think the facts would indicate. Far more prejudicial than I think any probative effect. There's also the issue of the verdict form. And of course, the allegation is that the complainant was under the age of 13. Mr. Toms was 17 years of age or older, which would subject him to a mandatory 25-year minimum sentence. Now, there is a verdict form which requires the jury to make special findings. Yes, we found CSC. Yes, we find there's the age of the complainant is under 13. And yes, we find that Mr. Toms is over the 17 years of age or older. And that would be, excuse me, what is required in order to impose the 25-year mandatory minimum. What happened here was a conflation of the finding of penetration, as well as the finding of the respective ages of the parties involved. And which I get that the verdict form does say
Penetrate, count one, over 13, under 13, 17 or over, guilty. Count two, under 7, under 13, over 17, guilty. But what it does is it denies the jury the ability to make special findings so that they had some doubt or using their inherent power of nullification to say that, well, maybe we find penetration, but we're not sure about the ages because, this is something that wasn't reported until after the age of 18. Well, I mean, we don't know that this actually occurred before the age of 13. We're not sure. And therefore, maybe we have some doubts. But the only decision the jury was left with was either guilty or not guilty. And for that reason, we believe that there is reason to suspect the verdict form, reason to suspect the verdict itself. And even if they find that there is penetration, if they had doubts or if they were absent the special findings as to the respective ages, that would not trigger the 25-year mandatory minimum. And it should result, I believe, in a sentence, a remand for resentence within the guidelines. And so for those two reasons, one, we don't believe there's a fair trial, and two, we don't believe there's a fair sentence. And for either or both reasons, we respectfully ask the court to reverse and remand.
Any other questions for Mr. Simon? All right, you'll have time for rebuttal.
Thank you.
Good morning, Your Honors. Jennifer Bruggeman on behalf of the people, Lenawee County Prosecutor's Office. Good morning.
Good morning.
So with regard to the first issue, I think I lay out everything pretty well on both issues in my brief. With regard to the flea checks and the number of incidents, obviously that initially came out at prelim and on cross, actually. Cross-examination, the victim was continually asked to kind of put a number on it or estimate, or how long did this occur? How many years did this occur? Things of that nature. And that's how she came up with that number. So then obviously the prosecutor, they added the count of CSC second as a result of that testimony, and then also filed the notice. Trial counsel again admitted that the evidence would be admissible under 768.27A, but argued the 403 issue, which is what is being argued here. But again, one, the nature of the testimony, both at prelim and at trial, substantiated that this was a sexual nature. It wasn't just what is labeled as quote unquote flea checks. So that term sounds very vague and non-sexual, right? But when the victim testified, she clearly described what would happen during those incidents and whether she was clothed from the top down or clothed from the top up or no clothes at all, and what the defendant did to her during those incidents. Also, she was the only one from her testimony that that was done to. She was not aware of any other of her siblings, her step siblings, that the defendant did that to. So yes, this was a delayed report. I think there's testimony in the record as far as, yes, the victim ended up moving in with her friend's family and ended up going through counseling, things of that nature. But there's also testimony that she did not discuss these things at length with her friend's mom, which was kind of the MO of defense counsel at trial, that this was encouraged and made up in a sense. And so, I think the testimony actually goes against that. In the end, just as I referenced in my brief under the Muniz case, again, just because this propensity evidence is allowed in, it doesn't lower the quantum of proof that the prosecutor must show. So I think, again, in light of the testimony and all the circumstances around it, there certainly was no error here as far as allowing that evidence in. And again, this ended up being part of the charged conduct. With regard to the verdict form, my first position is that this issue is waived. Defense counsel specifically approved not only the jury instructions, but the verdict form. So I don't even believe that this should be addressed from a plain error analysis in terms of whether the verdict form and the instructions were proper. But as far as from an ineffective issue, again, I think the Kellis decision that or the opinion that I cited to, I know it's unpublished, but it's relatively recent and it's pretty much identical to what the issue argued in this case is. And the verdict form that was used in our case is also very similar to what was used in the Kellis case. The verdict form, again, described that the victim should be under the age of 13 and the defendant should be over the age of 17. And then obviously the options were guilty, not guilty, and there was no special findings. But again, there was no indication at trial that the age of the victim or the age of the defendant was ever disputed. And the specific incident that we're talking about from the CSC first, she was 4 or 5. This is not as part of the flea check issue, so she wasn't getting up there in age. This was when she was 4 or 5 years old. She was on the chair. She described this at length at trial as far as the defendant digitally penetrating her. So lastly, defense counsel again didn't specifically request 3.32. The trial court is not obligated to use that form. And again, all the issues were adequately presented to the jury. The jury was instructed properly and the verdict form is proper. And certainly, even if defense counsel should have objected or should have asked for that form, certainly in light of the entire testimony, there is no prejudice here. So I'd ask the court to affirm.
Any questions? No. All right. Thank you. Any rebuttal, Mr. Simon? All right. Very good. Thank you. We appreciate your arguments and for your appearance here today, and the case is submitted. I'm afraid the venti coffee at Starbucks has caught up with me. So we're going to take a brief recess now, even though we're not at the end of our 10 a.m. case call. So we'll be back in just a few minutes.
The Court of Appeals of the State of Michigan is now in session.
Be seated. All right. Welcome back. Item 6, docket number 374-801, Hassan M. Ahmad versus the University of Michigan.
Good morning. Brian Schwartz, appearing on behalf of defendant appellant Board of Regents of the University of Michigan. Try to keep it brief because I understand Judge Goodall's preferences for short argument and try to keep some time for rebuttal.
I love a oral argument. I don't know what you're talking about. I'm serious. That's my favorite part of this job, honestly.
This is a FOIA case that is not about documents that describe the inner workings of the Bentley Historical Library at the university. Instead, as you're aware, this is a case that involves a whole bunch of private documents that were donated and whether those documents constitute public records. The primary flaw with the Court of Claims argument or the Court of Claims ruling is that these documents are public record. And we believe this comports with the definition of public record, the purpose of FOIA. The purpose of FOIA is to provide full and complete information regarding the affairs of government and the official acts of those who represent them as public officials and public employees. It only requires public bodies to produce public records. And key to that is the definition, which, it requires a writing to be prepared, owned, used, in the possession of, or retained by a public body. But importantly, it's got to be in the performance of an official function. So all the case law describing this talks about some active component actually using the document and utilizing it in some way.
Mr. Schwartz, I personally am inclined to agree with you, but why are we entertaining this argument? Because we have a prior ruling of this court and what we will come to be known as Tanton 1, which it appears to me is law of the case.
Sure.
Why is it not law of the case?
Sure, and I anticipated you'd ask that. So first, as you're aware, it is a kind of a discretionary rule of law. It's not mandatory. Second, the posture that this first came up was a C8 motion. Whether a plaintiff has actually pled a claim that he sought public records and was denied.
Mhm.
In a situation like this, where if you just say, well, you got a reversal on a C8 motion, it essentially means you automatically win the C10 motion, which can't be the case and wouldn't be true. And I think discovery has also confirmed and as reflected in some comments in Judge Gleischer's opinion, where she expressed reservations about the Court of Appeals ruling, and where she said if she was writing on a blank slate, that the documents have never been used in a public by the Bentley in furtherance of her performance. Judge Gleischer said there's in her September 15, 2023 opinion, she said, quote, "There's no evidence that the Bentley has used Tanton papers in furtherance of a government function." She said later on in the same case, quote, "The Tanton papers have nothing to do with the university's function or with the function of the Bentley Library or with the function of any government entity."
And she agreed with Judge Borello, who was sitting at the Court of Claims when he reached the same conclusion.
Correct.
In Tanton 1, right?
She had the benefit of seeing a full discovery record there. And, part of it is, I agree on the exemptions. The university, those are affirmative defenses. We bear the burden of proving, the exemptions, but a public record is part of plaintiff's elements of plaintiff's case. Judge Gleischer was not convinced that under the actual facts as they were disclosed during discovery and presented in the briefs, that these were public records. So as we note, there's got to be some connection. I don't think there's any connection between the closed Tanton papers and the activities of the Bentley or the university. I think Judge McCormick's ruling, obviously we cite that because she was in favor of our position.
Chief Justice McCormick.
Chief Justice McCormick.
Right.
She wrote, "The storage of a private citizen's personal writings and papers subject to a limited use agreement does not transform those documents into public records for the purposes of FOIA." And that's a principle that applies regardless of the contents of the record, regardless of what hot button political issue maybe or the requester might think they have or the contents in there. It's something that is kind of integral to the Bentley's role here. It's got to be able to take these documents and adhere to these use restrictions and some subsidiary issues, which I'll touch on briefly. I know the prior panel and Pali makes a lot of hay about, well, the Bentley collects and preserves, and therefore it possesses them. I don't think that, and our position is that can't turn every single document that comes into possession of the Bentley into a public record. If somebody leaves documents there and they hold them, say we'll hold them for safekeeping. Well, it's an entity that collects and preserves. Therefore, every document I just left because I left my backpack in there suddenly becomes a public record. I think at most, since the Bentley's functions deal with kind of curating and collecting, might deal with policies related to curating and collecting. Those might be public records. The gift agreements might also be public records, but the contents of what is donated pursuant to the gift agreements are not. And I was trying to think of a way that this, kind of runs, makes it really inconsistent. There are, to provide like an example, the statutes require hospitals to keep medical records. There are public entities that are hospitals. So this public entity's got to keep medical records. Suddenly all those medical records are public records. And then a public body's got to go through an exemption process to figure out what's exempted. I think that's the end result and logical result of the prior panel ruling. I think, and as we've also noted, this is a little bit, more of a policy argument, but we noted the implications of what the Court of Claims ruling is here. This isn't just like hyperbole that it's going to, first time we were up on appeal and briefing in the Supreme Court said, an amicus brief that said people are going to stop and not donate records. Well, that's happened here as this case has gone on since 2017. We provided the example of Juan Cole, who wanted to donate records to the university and keep them under seal. And the Bentley had to tell him, We can't guarantee that now while this case is going on because we have, this is what's being challenged here. So what did he do? He didn't donate them to the Bentley. He sent them out of state. He sent them to Northwestern. Who knows what will happen? There are other concerns that happen. People aren't satisfied that their donation, the agreements will be honored. They might not donate them at all to anyone. They might burn them, destroy them. And then a critical piece of what the Bentley's mission is, which is preserving the history of the state of Michigan, is going to be lost. Even if the documents are public records, and I realize that is something that's addressed by the prior court ruling, but the exemptions and the possible exceptions from that were not addressed. I believe there are a couple different reasons, and which I just want to highlight them. I know we touched on them. I want to take them a little bit out of order because I want to talk on the Michigan Community Foundation Act and the Library Privacy Act first, because those ones are kind of unique to the Bentley itself. As you're aware, the Community Foundation Act contemplates, I believe, the very thing that happened here, that a private individual is going to donate something to a library with conditions. That's what people do when they donate stuff. There's usually some explanation. They don't just drop it off. And the statute says that a public library may accept donations, quote, subject to the conditions and limitations, if any, set forth in the instrument of the gift. Provides flexibility for a public library to accept gifts while recognizing that there might be those strings attached. And this is an example where I think the legislature has determined that adhering to those gift conditions, which might not include sharing the gift with the public for a certain period of time, outweighs other interests, which might include incorporating them and using them in the performance of an official function. I don't think there's, the statute doesn't say the library's got to accept them and follow the instrument of the gifts, except if someone makes a FOIA request. They could have said that. There's references to FOIA and other statutes. They could have carved it out and said, this stuff is going to be FOIAble, and that's the exception. And the legislature didn't do that. On the other hand, I don't think that there has to be a reference in FOIA to be able to rely, or a reference in the Community Foundation Act to be able to rely on the pass-through, the exemption in Section 13(1)D to rely on the Community Foundation Act as another statute that exempts records.
Can you give an example of that 1D being used as an exemption where the exemption isn't specifically identified in the statute?
Yeah, we said it on page 8 in our reply, but the first one is the King brief. It does talk about
That's the Oakland County child killer case, King?
Yes, I believe so.
Okay, go ahead.
So it does, the statute there does say shall not disclose. It doesn't reference FOIA at all. And in a lot of those cases where you have references to shall not disclose or this is not disclosable under FOIA, those records are indisputably public records to start with. They're like the statute requires them. In some instances, the statute requires the public body to create them. So it makes sense that the legislature would put something in there that said, yep, we're making you store these things, but we're going to carve it out. In a situation like this, where it could be all sorts of a manner of things that are donated to the library, it wouldn't make sense to put a carve out for FOIA.
Can you explain King one more time? I didn't follow your argument.
Sure.
I felt like you were talking about it and we went in a different direction.
Oh, sorry. So the statute does say certain things shall not be disclosed. And I actually, if you bear with me for a second.
Shall not be disclosed under FOIA. It makes the specific reference to the statute.
I do not believe King actually specifically refers to FOIA.
But some do. I mean, that
yes,
was
I will readily admit that there are a lot of statutes that say that. And the Michigan Open Carry statute also, it cited, there were two different, the Michigan Open Carry versus Department of Police is another case where there was, there's a provision in the statute where it said shall not be disclosed unless authorized by law. And the plaintiff was arguing, well, authorized by law is FOIA. And the state said, no, that's not a reference to FOIA. So I believe those are kind of two examples, but and it's a situation where it goes both ways, but I think it's clear that since there are exceptions out there, it's not the mandatory rule that there has to be a specific reference there. Turning briefly to the kind of the Library Privacy Act, this is kind of a related statute, which is clearly just focused on libraries. And that allows the library to, specifically the library employees, to the exclusive discretion to determine the use of library material. It says, except as otherwise provided by law or regulation, adopted by the governing body of the law or of the library. The use of library materials shall be determined only by the employee of the library. The except, I know Pelley makes this argument, except as otherwise provided by law. It means FOIA. But if you actually read the whole sentence, except as otherwise provided by law or regulation adopted by the governing body of the library, that would be, yes, employee, you could do it, except if your boss, the Board of Regents, were to adopt the policy, that is the policy or law that would be at issue here. There's no, FOIA is not, I don't think FOIA fits within that definition. So we believe that the Library Privacy Act provides an alternative and independent reason to exempt these records. Finally, just the personal privacy as well. Believe that these documents clearly constitute information of a personal nature. These are his private collection of documents. He determined that these are important to my life and then donated them to the university, expressing his intent that they remain confidential for 25 years. I believe it would also constitute a clearly unwarranted invasion of his privacy. Having anyone dig around your private papers when you said don't look at them for a while would clearly infringe upon him. And I know on his rights, and I know he's deceased right now. And that's, you know, that was a comment that was made by Judge Fleischer's opinion. He's deceased. But he entered into a contract. That contract right doesn't just disappear. The gift agreement doesn't just disappear on his deceased. The university can't just say, well, he died. We're just going to willy-nilly won't agree to it.
Well, you just made a privacy interest into a contract right. Are they the same thing?
No, but I think the contract right, they're related here because I think the contract right provides evidence of his privacy interest.
Right, but you're pointing to an exemption, and that exemption is privacy.
Correct.
And then you're saying, well, there's a contractual privacy interest. And that's where you're losing me.
Sure. I started to take a step back. I didn't mean to say there's a contractual privacy interest. I meant to say that his privacy interest, that I'm using the contract as reflective of him explaining his privacy.
The contract is an indication of his desire for privacy. Would that be one way of putting it?
Correct.
In perpetuity. Well, at least, or in terms of the agreement.
Correct.
So your position is that the fact that he's deceased, we shouldn't point to. Instead, we should look at his intentions as expressed in the agreement.
Correct. I mean, donations of property happen all the time where someone makes, you know, and with even in trust law, stuff happens where things are going to happen after a person dies. We can't just completely disregard them. I think here you're using it. We're not saying we're contracting around FOIA by use of a contract, but using this contract as evidence of him asserting his privacy interests. And it's in the record where his whole reason for asserting and asking for them to be closed. He said, this is just paraphrasing, but he says, I think the confidentiality or my privacy interests have been infringed. I want you to keep them closed for more time. And that's in the record. So I believe that helps balance. But I think the weakest part or the strongest part, of why this exemption applies is applying the core purpose test. And Mager and the Michigan Federations of Teachers, the court looks at that balancing and it says the only public interest is if whether disclosure would actually show something about that public body. And here it wouldn't. Disclosing the contents of these records, there's nothing about them. And maybe there's a stray thing about the University of Michigan in there, but they're not University of Michigan records. They're not about the University of Michigan. And this is trying to use a statute here in a complete way, which was never intended. I'll rely on my briefs for the constitutional autonomy argument and the punitive damages argument unless there are any questions.
Any questions for counsel? I think you argued all of that in the proper order. Mr. Ellison?
Yes, good morning. Philip Ellison appearing on behalf of the FLE. Good morning. It's been a hot minute since I think I've been for any of you, but it's good to be here this morning.
Welcome back.
Thank you. If I can leave one point that I could have you write down and take with you today is to look at the Bradley versus Saranac case. The entire argument of the university collapses under Bradley. Bradley says there was a Michigan Court of Appeals case that was later affirmed. The principle that I'm describing was affirmed by the Michigan Supreme Court. You cannot use a contract to get around your FOIA obligations. You've heard this morning that it's not a public record because of the contract. We've heard it's not a public or it's not a privacy because of the contract. And I get the creative way he's trying to establish this, But the important part here is that contract, the gift agreement that they call it, which it's a pretty big stretch to look at the actual gift agreement and call this a gift agreement when I call it nothing more than a receipt. But even if we had treated it as a contract in that respect, Bradley precludes the arguments that the university is making.
That's true if they're public records in the first place that you can't contract away. So, I mean, we don't need to go there.
Fair enough. But the point I guess I'm getting at is to look carefully because the arguments of the university are very, and I would use the word, and I mean this respectfully, stealth. They're trying to use this agreement as both a shield and a sword to avoid the very thing that both that this court previously said in Bradley and the Michigan Supreme Court affirmed there. So I would ask the court, if you take nothing else away from what I'm at today, please look closely at Bradley because I think that answers most of the questions that you need to answer as part of this particular case that's before you. Now, that said, going to the public record portion of this, Judge, I appreciate it. I think the law of the case applies. I respectfully disagree because it also applies as the law of the case to the Court of Appeals, and you're being asked to review the Court of Appeals decision, whether there was error, and the Court of Appeals was bound by this court's previous decision. There's I think a disconnect between us, Brother Counsel and I, as to whether it's binding authority or law of the case. Binding authority is for other parties in other cases. Law of the case applies because these were the parties that were there before them. And even if the Court of Appeals is not binding law, or excuse me, not law of the case authority, certainly when the Supreme Court by even division affirmed the Court of Appeals, because even division affirms the Court of Appeals decision. It does not change that decision. This is actually a Supreme Court blessed outcome of that case.
The only three justices who opined disagreed that these are public records. And two of them said essentially it's not ripe for review. So whatever the outcome is here, I wish you luck in the Supreme Court because I think you'll need it. But go ahead.
I'm hoping we don't end up there, but
you will.
I think your foresight is going to end up being correct in that respect. One of us is going to end up there. Yeah. That said, I do believe, though, however, to make the record complete, that these are public records because what we're asking for these records to get access to them because part of what they are is, and again, we have the five, what I like to call trigger words of what a public record is. Is it prepared, owned, used, in the possession of, or retained? There's several of these. They're owned by them. It's retained by them. What the university keeps pointing is they have been used, but used is only one of the five different of the list of those. And each of those are a separate enumerated trigger to whether these become public records. The next argument, of course, from the university is but they're not being used in a government function. I disagree. And this is where I think that what the Bentley Library is designed publicly to do is to retain the history of the state and of the university. Somebody made a public decision for curatorial purposes. They found that the Tanton papers were important enough to be part of our public university and our public body system to retain those papers. That was a decision that was made, and that's subject to FOIA review unless a exemption applies in these circumstances, which we'll talk about in a second.
Mr. Ellison, should we be concerned at all about the externalities, to use an economics term, of the Tanton 1 decision? That being, as Brother Counsel pointed out, if Tanton 1 remains good law in perpetuity, individuals will be clearly disincentivized to leave their papers to this library or any other library. And that has potentially, I don't think that's a good outcome personally. I don't know that that's a legal argument. Maybe it's an argument that ought to be made to the legislature. But I wonder if you might respond to that. I would ask you to respond to that.
I mean, when governments make a decision, we're trading things. When we lower the speed limit, to save lives, we burn more gas, right? When government is all about trading off balances and trading off positives and negatives in that respect. And the trade-off to make those decisions does not belong to this body. It belongs to the legislature. I would point the court on page 16 of my appellee brief, footnote 8, I cite to the Curry case, Curry versus Meyer, I call Meyer Stores, but Meyer Incorporated. the importance of making policy decisions as opposed to legal determinations belongs in the halls of the legislature. I normally would say up the street, but we're at the Detroit here, obviously, but that belongs in the Capitol Dome in the legislature. At any point, the university has a large bullhorn. If they think that there should be a donor exception or a library curatorial exemption that should be added, we have seen in the 9 years this case has been pending, the legislature has passed new exemptions. In fact, the most prominent one being school and cybersecurity exemptions. But we have to at least infer that at the universe, or that if the university has not been successful in advocating to the university to create such an exemption cannot be created by whole cloth by this body, in whose job it is to interpret the law. So in short, policy, as Curry tells us, policy decisions the trade-offs, if you will, belong to the legislature, not the court. Turning very briefly to the exemptions, it's my position, and you have a very well robust made record of, I think 4 or 5 indices that the court below allowed the university to amend and re-amend. And when I say amend, they didn't really add anything new. They continue just to remake the same assertions over and over again. The burden here was not met with the personal privacy exemption. The only caveat carve out was that, as Judge Gleicher found, that there was a piece, because we weren't permitted, even though we asked, we were not permitted to review these records, which is one of the most ironic twists in a FOIA case, because I'm not sure I've been before you with a FOIA. I know I've been before both of you with FOIA cases for sure, respectfully. FOIA is the unique, weird case that when I start a case on behalf of a FOIA denier or a person who's been denied FOIA request, is all I have to do is simply place that I had made the FOIA and it was denied, and the burden shifts to the government then at that point going forward. It's a weird backwards kind of legal world, because I don't have the burden. That's where I respectfully disagree with brother counsel. So long as I establish that I'm a disappointed, and that would be the phrase I would use, a disappointed FOIA requester, the burden falls to the government alone to meet their burden that these records should be withheld from the public view, because there's a presumption that the records should be open, and any exemption is, we've cited over and over and over, and I know we have, in fact, probably written in opinions that have been made, narrowly construed exemption. They're narrowly construed in all instances, and that just hasn't been met here. Just to finish up the exemption part, unless the court has any specific questions, the Community Foundation Act, I did point an argument brother counsel did not address and has largely ignored, is the denial of the FOIA request happened on May 8th, 2017. And I'm shocked to even be saying that out loud. But the Community Foundation Act did not get enacted until August of 2017. And there may be this argument, well, this court case has been pending on all this time. State News, which is a Michigan Supreme Court case, has told this court you can only look at exemptions at the time that the denial occurred.
I'm glad you brought this up, because I had a question about it. Wasn't that 2017 Public Act a recodification of an existing statute which contained, if not identical, very similar language?
I have some thoughts on that. It's not identical. I will say that. I'm not
sure it's fair to characterize it as retroactive, and for that reason, it's a recodification of an existing statute. If you change one word in that section, you have to reenact the law. I don't think that necessarily makes it retroactive.
That may have been a good argument for the university to make below, which was their burden to make. They did not make that. And so we raised the argument that the Community Foundation, which was the sole basis of their, it wasn't the previous predecessor act that they relied on, because there was no Community Foundation Act that existed previous. This was a whole new section there. Now, there may have been inspiration in borrowing from other acts and consolidate them in some fashion, and the university could have relied on that predecessor act, but they did not do so. And by not raising it out, they waived it at this point, would be my argument.
Okay.
That said, the pass-through exemption requires, and we have this briefed out, and I won't spend but a few seconds to say, the pass-through exemption requires specifically described and exempted records. And what the university is arguing here is that the Community Foundation fits again because of the contract. Now, I would argue to this court that the Community Foundation Act, which speaks to subject to the conditions and limitations, and what the university is tying that to is the contract. The problem is gets back to where I started. In Bradley, you cannot contract away your FOIA rights. So you can't use a contract that's illegal on its face and a contrary and a violation of public policy to be the hook to get you in to get around the FOIA obligations. So again, I come back to where I start with this is Bradley is an extremely important principle for this court to apply because again, the contract keeps slipping its way into these arguments by the university. And as to the library exception, except as otherwise provided by law, that is truncated. I would acknowledge that. I mean, we truncate things for brevity in any court case. The legislature is the boss of these libraries. These libraries are a subdivision of the state, and therefore they're subject, the boss, if you will, is the argument I heard from Brother Counsel, I think was the phrase, the legislature is the boss. And so you have to follow what your legislature says, not just what your immediate head librarian says in this instance. I'm going to rely also on the university autonomy arguments in the brief, but I will lastly ask this court if you were to indulge me as a FOIA litigator, probably one of the most common FOIA litigators probably in the state, I would ask this panel to look carefully at overruling local area watch. Local area watch was the law that was interpreted under the predecessor statute. The statute changed in 2015. The courts below, the only one I've managed to convince so far of this is Judge Yates, sitting as a court of claims judge. By the way, welcome aboard. The trial courts are relying on local area watch because they said this is the binding precedent that's there. It's the same, MCL citation, but the legislature rewrote that section. And if you have on page 38 of the Eppley's brief, I've highlighted the differences. They took what was originally the damages portion, uncleaved it, put a fine onto the conditional part, and then made the $1,000 punitive damage penalty mandatory, not conditional. I would ask this court, and I'd even go as far as to ask this court to do it in a published opinion, to find that local area watch, I don't want to necessarily have been overruled, but it's been superseded by statutory amendment.
I don't think we'd have that authority to overrule it. The Supreme Court would. We'd have the ability to make that observation. Certainly.
I think you respectfully.
When was it issued? What year?
Well, local area watch is not a Supreme Court. It's a Court of Appeals decision.
I know.
2014. I was on it.
Okay.
Yeah. So it was right before.
We could call for a conflict panel, but I don't think you're going to have 3 votes for that.
Well, the reason I would respectfully argue that local area watch interpreted the statute as it was then. The statute is no longer the same. And so it's not a matter of asking to overturn the same statutory language that was there, but because this is a new statute, local area watch was correct for the language that was there at the time. It's not correct for the language that's there today.
Just to make sure I understand your argument.
Yes.
And this is just practical terms.
Sure.
We're departing from the language of the statute. I just want to understand the contours of your argument. If you had a FOIA that you prevailed on of 3 pages, okay, 3 pages were wrongfully withheld, and you were entitled to compensatory damages of $50, $100, whatever it happened to be. Would you also, as punitive damages under your understanding, be entitled to $1,000 as punitive damages?
The way I would interpret this, again, just to put a fine point on it.
Right.
I'm not saying this, the legislature is saying this.
Okay.
My argument in support of the legislature would be is that the legislature has made the condition of a punishment of a fine confined to the condition, meaning the arbitrary and forget the exact.
Arbitrary or capricious?
I don't know if it's capricious, but it's arbitrary, the arbitrary nature of the denial. It took away those conditions as a basis for damages. And so damages are so my reading is damages are mandatory in any FOIA violation case going forward.
You said damages, but the language that the legislature used was punitive damages.
That's what I'm sorry. I didn't mean to cut that off because you are entitled to damages for a FOIA violation under section 4, I believe, of the FOIA statute. Most FOIA cases don't have, someone isn't usually damaged by FOIA, meaning they lost a contract or they lost out on something. And that I have yet to find a case where someone has suffered actual compensatory damages as a result of a FOIA denial. And I think that's the legislature might have realized that as part of the amendments. And these were part of the 2014 that became enacted in 2015 amendments to the FOIA statute. I think the legislature, when they're, and if you look at that statute as a whole, they were trying to beef up that statute. They redid the cost section. They added section A and B. These were provisions that actually tried to strengthen and also added punishment to public bodies who failed to comply with the FOIA Act. So what I'm asking this court to do is reparse out that section, determine that local area watch is the binding law for the predecessor statute, but the new statute is something that's new and fresh, and that needs to be addressed in the first instance. And whatever this panel says that means, we can live with, but at least it needs to be addressed for the first time because it's not being addressed by trial judges because they think they're automatically bound by local area watch because the MCL remains the same. Thank you so much for your time this morning. Is there any other questions I can answer?
Any others?
No, thank you.
Thank you very much.
Rebuttal?
Thank you, Your Honor. First on the Bradley case, I believe that case is easily distinguishable. That is a case where whether the documents were public records or not was not at issue. The issue was whether a collective bargaining agreement or the public body there could agree with a union whether certain documents were exempt. That's not the certain otherwise public records are now exempt. That's not the situation we have here where they are private records and we're trying to figure out whether they're public records. Regarding the comment about, well, there's a policy determination that needs to be made in the legislature for a donor exception. There is. The legislature has done this in the Michigan Community Foundation Act and the Library Privacy Act. And the comment that, well, the legislature, I think it was the legislature is the boss of the library. That might apply to some libraries, some state libraries, but the university has control over the Bentley. The legislature can't tell the Bentley what to collect. That would be a violation of the university's constitutional autonomy. Judge Godola, there was a question about the retroactivity of the Community Foundation Act, and that was cited in the prior panel's footnote 5. They said it's substantially the same. I don't think that's when it's not raised below. I think it was preserved by us. We've argued that it applies, and it applies to the issue here. So I think it's an appropriately preserved argument for us to make. And my last point, just briefly on the local area watch point, we believe, and it's in our brief, that still applies. They're punitive damages. Punitive damages have to be tied to something.
Some sort of misconduct.
Yes, it's like punitive, like you have civil fines if there's an automatic violation, but this would be probably the only time in probably the country where there's punitive just for a violation. Usually there's a violation and you got to do something really bad to get punitive damages. And the facts here, I don't think there are.
And just a point of clarification, I said I was on local area watch at I was on a different Grand Rapids case. That's M Live Media Group, Grand Rapids. That's out of it's 2017. The local area watch was a 2004 case.
Mr. Ellison restrained himself by not correcting you on that.
Yes.
Before your time,
Yeah.
Dates you or age you on that.
That's right. Well, he's expressing that restrainment, right?
Yeah,
Restraint right now.
I did notice that I had wrote 2004, but I thought I made a mistake.
2017.
Thank you very much. We asked obviously that the court reverse.
Yep.
Thank you.
Thank you.
Appreciate it. Very interesting case. Well presented arguments. Thank you for your appearance. The case is submitted. Item 7, docket number 374495, Carlos Ledesma, MD versus McLaren Bay Region.
Good morning, Your Honors. May it please the court, Mark Bree on behalf of appellant Carlos Ledesma. Before us is a narrow and specific appeal in terms of whether the trial court erred in applying a gravamen analysis to determine that action for defamation and an action for tortious interference were both bound by the same shorter statute of limitations of 1 year because the underlying harm or actions were defamatory in nature relating to the tortious interference claim. In short, there's case law in Michigan and specifically as relied upon in the briefing, Wilkerson v. Carlo, that held verbatim or very clearly in there that just because the underlying harms, or at least a large part of the underlying harms, can be defamatory in nature for a tortious interference claim, the two can mutually coexist. And the main aspect of such analysis is the independent and unique elements required for pleading a tortious interference claim. And specifically as it relates to this case, the reasonable expectation of a business expectancy or relationship and knowledge on behalf of the defendant in this case of the same. As outlined in the brief, it's clear there's requirements for the querying of the NPDB data bank, and as such, any kind of negative reporting of the same would be reviewed by future employers. And while obviously that issue and the specific nature of the factual underlyings are not at issue, it goes to show and was alleged in plaintiff's complaint that these harms were alleged, that this report, while could be defamatory in nature and could exist solely as a defamatory claim, does not preclude the coexistence and the allowance of the tortious interference claim. And obviously is why we're here is there's been no disputing or contesting that at the time the complaint was brought that the defamation claim was time barred. But however, there was also no dispute and concessions from both sides that the tortious interference claim was not time barred. So it's really just kind of looking into whether the gravamen analysis of the set of facts underlying each case or each claim, in this case, the publishing and the filing and reporting of the National Practitioners Data Bank report, allows the coexistence of both a defamation claim and a tortious interference claim.
Is there a separate process by which a physician who might be on the NPDB, do they have any ability to challenge inclusion?
Right. So
because I think this is somewhat a consumer protection.
correct. And in that case, no, there's not. So the National Practitioners Data Bank has no investigative authority to it. They look at it in a very black and white nature of if there is an action taken that negatively affects their rights and their privileges for a period of greater than 30 days, that must be reported. Whether the report is completely fraudulent or it's completely accurate, they have no ability to kind of investigate therein. And unique in our case, and actions taken by plaintiff in this was upon learning that the report was published, he was reaching out both individually and on counsel on his behalf to defendant in this case to say, hey, we need to have a hearing on this one. There's no disciplinary record. There was never any issues of that kind. We need to figure this out. And in response, defendant in this case stated that because under their medical professional staff bylaws, that because the application was for temporary privileges, there's no right to a hearing on any decisions being made for the underlying determination. So here it's reached out to National Practitioners Data Bank, and they understandably stated of like, look, there's no investigative powers from our end. There's obligations for these hospitals and entities to report if specific actions trigger certain restrictions or negative adverse effects. In this case, it's alleged that they did. As such, McLaren was just required to submit this report. There's no fact checking of, was this a reasonable one? Did you have bases for those? And those are all issues that we fully intended to bring up in the trial court as discovery remained ongoing for it all. But for the purposes of here and no, there's no other kind of way through either the hospital or through the legislature, but the bylaws and everything else is it's really kind of a perfectly insulated mechanism from McLaren's side of it of the report can be done. There's no rights to be done or obtained through the NPDB because of, as I mentioned, they have no investigative authority. And then likewise, there's no actions to be kind of taken up through the chain of command or under the regulations and bylaws of McLaren, because as stated in those bylaws, that because the application was for temporary privileges, such applicants are not afforded that right to the due process of having an understanding and support for why these actions were taken against their privileges, and thus in turn, the NPDB report being filed.
And do practitioners have any advance notice that they'll be placed on it?
In this case, plaintiff learned of the denial of the privileges. And then and I'll be very brief on it, but for just context, in the brief is stated, he worked previously through Bay Imaging PLLC, had privileges at McLaren, Bay County or Bay City, went to another McLaren entity in between, but then has been out in California for the previous 7 or 8 years, is the head of a radiology program at numerous hospitals, one of which came up for reapplication for privileges, applied, and at that time learned that there was this report kind of outstanding kind of over his head. And that kind of triggered as aforementioned, the investigation, the request into, hey, why is this? There's no disciplinary records. There's nothing ever happened to support this. And it's obviously negatively impacting everything. And as stated, it's already happened once that the application at that hospital, Lakewood Medical Center in Lakewood, California, was denied on the specific grounds of our bylaws state, and it's our position that those are very customary for the field, that this negative report on your NPDB query bars you from application for 10 years. So until July 2031, the individual, Dr. Ledesma, who is the head of the radiology program, of which Lakewood Medical Hospital is part of, is unable to obtain privileges there because of this NPDB report. So again, it's kind of a not difficult, but a perfectly insulated mechanism from a hospital side of these reports can be made. In such case, the bylaws, there's no dispute, state that when temporary applicants are having their privileges affected, they don't get the right to this hearing. So in this case, applied, not only had no issues at McLaren, no documented issues and no issues in his recollection or his position ever at McLaren, that not only worked at another McLaren facility in Lapeer, but 8-9 years had passed since that time, comes back to apply for temporary privileges, and now learns that these allegations have been made against him from 8-9 years prior, based on no written disciplinary records, based on no personnel files, anything supporting the claims. And he's kind of stuck in between a rock and a hard place of can't go to the NPDB, not afforded the due process hearing or the hearing on the decision. And it's kind of stuck right here now of there's no other choice really than to pursue an action against the hospital on those grounds for kind of righting that wrong in his mind and ultimately getting that NPDB report kind of repealed or voided is effectively the mechanism for the same.
I appreciate that. And thank you for indulging my need for education in this area. But to ask a follow-up question, the crux then is because he applied for temporary.
Correct.
That he is denied any avenue of relief in terms of a process to challenge his placement.
Correct. And with a caveat that I don't have those bylaws present in front of me, but as a confident recollection, and sister counsel is obviously, if I'm incorrect, can correct it there. But if it was not on the temporary basis, if it was for full privileges with the hospital, that it is my understanding and recollection from it that had the same denial happened, the same reasons, that he would have been afforded a hearing into the merits of it. And where it goes from there is can be anyone's guess for it. But in this particular purpose, there was no right to any sort of hearing or any sort of explanation or challenge to McLaren's decision within the confines of the hospital and that structure itself. It was really, you were temporary privilege, nothing else. Sorry, live with the decision.
Okay, thank you for that.
Yes. So as stated, there's been multiple cases, but the primary one relied on in both our initial appellate brief as well as our reply is Wilkerson v. Carlo, which, while some of the facts obviously differ, the underlying nature and primary argument by defendant in that case was the same. It is because that the underlying damage or harm is defamatory in nature to the tortious interference claim, that the two cannot exist. As stated, that is completely disputed or ruled against in Wilkerson, as it stated that, another argument that was made therein was that even if this case could have fully stood on its own in just defamation, there was all of his wrongs could be righted through just a defamation claim. That alone also does not bar or prohibit the bringing of the tortious interference claim. They are two long-standing and recognized claims in Michigan. And as mentioned, they have differing and unique elements to the same. And one specific one, which was addressed in the response brief from appellee, was that because the damages were the same, that it was reputational and economic in nature. And what's really just relevant for this case herein is for the tortious interference claim, one of the required elements to show is damages suffered as a loss of the reasonable business expectancy or relationship with it all there. That was alleged in the complaint, that it was, as stated before, this Lakewood Hospital denied it specifically on the grounds of these ones. These NPDB data banks are mandatory for hospitals to query them for any application, either initial for privileges or for the every 2 to 3 year mandatory reapplication for privileges. They are mandated to check that NPDB bank for these reports on these physicians. And specifically, and more relevant to that one, is there's not only no case law stating that it's improper or a plaintiff may not also allege or seek damages to his reputation or professional image with everything, but there's even cases that, while do not black and white assert the same, and Wilkerson being one of them, but that it's not facially improper to allege both, so long as the mandatory element of the damages to the professional and reasonable expectations or relationships were harmed. In this case, that was clearly there. And further to that point, defendant appellee's response brief specifically indicates and acknowledges our argument that all of those elements were pled, and defendant appellee specifically states that it will not opine as to whether or not those matters were specifically pled in our complaint. From our position, that decision is pretty straightforward. Is under Wilkerson, doing so would be fatal to their very argument of, by acknowledging that the elements of tortious interference were met, as was included in the complaint and included in the briefing, that there is ample case law and binding authority that says these two claims can coexist. And it does not matter if all or part of the tortious interference with business expectancies claim, the harm of that is defamatory in nature. There's no prohibition on the same for that.
Counsel, I think we understand your arguments. In light of the fact you will have time for rebuttal. Is
Yes.
there anything more? you
Very
can
brief,
share with
yes.
us?
So, and I'll keep it very brief because it was also provided in our briefings, but the argument from defendants is just creates a very slippery slope in the sense of one bar being there's no argument that it's limited to counts specifically alleged in a complaint. And by that, I just mean if a party only brings a tortious interference claim in a certain way that is subject to the 3-year statute of limitations, but it's defamatory in nature, the underlying action, there's no prohibiting that from kind of limiting it down to the same. If this argument and logic is to be followed with the gravamen analysis, that it then likewise bars it to a 1-year statute of limitations. Same for if any kind of contract has a non-disparagement clause. Breach of contract is 6 years. If you violate the non-disparagement clause, safe to argue that it would be defamatory in nature. It's now reducing that 6-year statute of limitations down to 1 year. So not only does it effectively dissuade a party from bringing multiple or alternative theories because they might shoot themselves in the foot by being bound by the shorter statute of limitations, but there's not even a bar to just those claims brought. It can exist for, if any good faith argument can be made that this is just, claim A is just claim B in a different hat, and claim B has 1-year statute of limitations, whereas this one has 4, it should be bound by here. They're deliberately trying to game the system, the gravamen analysis. So it just really creates a very slippery slope of eliminating statutes of limitation entirely and really just negating or setting aside these long-standing and long recognized claims in the state of Michigan. So if there's not any other questions, I can address anything else on rebuttal.
Right. Thank you.
Good morning, Your Honors. I am Carol Fossey on behalf of McLaren Bay Region. I'd like to respond to Judge Rick's questions first, if that's all right with the court.
Yes.
Judge asked whether the physician can challenge the report. Indeed, yes. And indeed, Dr. Ledesma did that. The report was filed in August of 2021. He submitted a challenge, oh dear, I can't remember when, but he got notice of the report from the data bank in October of 2021, and he submitted a challenge to the report. Now, in all fairness to Dr. Ledesma, the data bank does not investigate whether or not the decision reported was correct. It investigates whether the report accurately reflects the decision and the reasons given in the report.
So it's just a repository.
That's correct. Your
Okay.
Honor. Anyway, the data bank did investigate that and found that the report was an accurate reflection of what occurred at the hospital and the reasons for the denial.
So he can challenge it, but the challenge is kind of meaningless because he can't reach the substance of the report, correct?
That is correct, Your Honor.
Okay.
Yes. But he certainly knew about the report shortly after it was filed. He got a notice from the hospital that said his application was denied. Now, I'm not sure that that notice gave him notice that there would be a data bank report, but it's almost an automatic thing, as Mr. Rao has said, and that is the hospital is required to report such a denial. It doesn't have a choice. And although the search of a report by other facilities, no, I'm going to back up and start this again. Other hospitals particularly, but any organization which credentials a physician must check the data bank for reports. Now, in this case, the organization which checked Dr. Ledesma's report had a policy that denied privileges for physicians who had data bank reports. But that is not a mandatory policy. Hospitals frequently accept physicians who have data bank reports. And in fact, it's becoming pretty commonplace nowadays because the data bank has been in existence for more than 20 years. And many, many physicians have reports in the data bank for whatever reason. The other thing I failed to mention is that Dr. Ledesma is permitted to, but for some reason did not, write a response to the data bank report that is submitted to the data bank. It is maintained in their records. And anyone who seeks data bank reports from the data bank gets the physician's response to that report as well. So he could have put something in there which said, this report is nonsense. He didn't do that. Now, back to the case at hand. The plaintiff has argued that he has pled a perfectly good tortious interference argument. We're not challenging that. However, the seminal case from my perspective is Kohlenberg versus Ramirez, 127 Mishap 345, which says, because the elements of the two overlap, a plaintiff may not bring suit, or a plaintiff may bring suit for both torts, as long as the damages are not duplicated. Here, the damages are duplicated. Dr. Ledesma has made no argument whatsoever that any particular damages have arisen from his defamation claim. He has not distinguished between damages that arise from the defamation or from the alleged interference. He has sought principally removal of the data bank report. He has sought removal of the defamation. There is no reason in the world that he needs to seek damages for tortious interference if the data bank report doesn't exist. He has made no separate argument that he's made no argument of any separate defamatory statement. He's made no argument of any separate publication. He's made no argument of any separate effects. He's not sought any separate equitable relief, solely the removal of the report. No separate monetary damages. It's all based on that single report that the hospital was required to submit. There has been a considerable amount of argument here today about how unfair the decision was to terminate or to refuse Dr. Ledesma's application. But that's not the basis for this lawsuit. The entire lawsuit is challenging the report, not the decision to deny his application. And however unfair Dr. Ledesma may have thought that decision, he is not in this lawsuit challenging that decision. He is challenging the report. I would also like to raise another argument, which was not the basis for the trial court decision, although it was an argument we made in the trial court. And that is, for a claim of tortious interference, if a defendant's actions are motivated by legitimate business reasons, then the action for interference would not be the basis for a tortious interference claim. In this case, the hospital had a very strong proper motive for filing the databank report.
But this goes to the merits, not to the statute of limitations question, correct?
Well, that is correct, yes, but it is another basis upon which, excuse me, this lawsuit should have been dismissed. The tortious interference claim could have separately been dismissed simply on the basis that the hospital was required to file the report. But in terms of the limitations, yes, you're right. It doesn't go to that argument. But certainly, if we go back to the limitations question, there's no real separate claim because there are no real separate damages. It's that simple. Are there any other
questions for
No.
council?
No.
I think we get it.
Yep, I think you do too.
Okay, thank you. Council, any rebuttal? Before you get to that, I'm going to ask you a question based on what Ms. Fossey just argued. What are your client's damages arising from the submission of the report? I understand he was, denied privileges at McLaren Bay region.
Correct.
So
his reapplication for privileges at the Lakewood Medical Center in California, those ones were denied specifically on the grounds for it. So
I just wanted to clarify.
Correct. And yes, and we have others which have not formally denied it, but have indicated similar rules and standards for it of this report serves as a bar to everything else for it. So just very brief, focusing just on the statute of limitations is, and I got the site and I forgot the specific case cited by sister counsel of just that the two claims can't have the same identical duplicative damages for it. And again, in reviewing the complaint, which was affixed as part of appellant's appendix, obviously they have similarities in nature due to the defamatory nature of the wrong alleged in the tortious interference, as well as the claim for defamation. However, as indicated before, the specific additional element of the harm to the business expectation or relationship is completely independent and unique to tortious interference, as it is not required by any means with defamation. And in our case, again, circling back to the main point of not only was that clearly articulated and alleged in the complaint, but the addition of, as well as the economic damages that have just been discussed, he's also suffered the reputational damages. And that goes again to there being no case law that we have discovered, but no case law that has been raised to point to the fact that a plaintiff is prohibited or barred from alleging reputational damages in addition to the mandated damages under the statute, or not the statute, but under the claim for it. So just in that case, again, it's the Wilkerson court is directly on point with it, that it states that it doesn't matter how similar they are. If you meet the mandated additional heightened requirements of tortious interference, the two can coexist. There's no issue with that. There's been, I believe the issue of failing to state a claim was raised in defendant's motion for summary, and it was decided solely on the gravamen analysis, tying the two statutes of limitations together. And to put more clearly, there was no dismissal for failure to state a claim. So in this case, If there's going to get into disputes of that, that's something for the finder of fact to kind of determine at that point. For this purposes, there was no findings that there was any deficiencies or improper pleadings for the tortious interference claim. It focuses solely on the two allegedly not being able to coexist, which, as I've now sure reiterated numerous times, the Wilkerson Court and others have held that that is by no means a bar to it. They are two longstanding recognized claims in the state of Michigan, and there's nothing in those cases or that have been brought here today or in the briefings that would provide for such a prohibition of the two claims coexisting together. So if there's no other questions.
Any other questions?
No.
Thank you, Your Honor.
Thank you very
Thank
much.
you.
Appreciate your arguments and for your appearance here today. The case is submitted. Okay, now being 12:20, we'll move on to our 11 a.m. case call. And again, just a brief reminder to the attorneys who might not have been present here at 10 a.m. We are familiar with your cases. We've read the briefs. You don't need to belabor the facts. Just cut right to the most decisive legal issues and tell us as succinctly as possible why you should prevail in your appeal today. And in cases involving minor children or protected individuals, please just use initials only and not proper names. Okay, I'll call the first case on the 11 a.m. call. It's item number 8, docket number 373470, Eric Allen Key versus City of Detroit.
Good morning. My name is Richard Shaw. I'm here on behalf of Mr. Key, the appellant in this case. The elephant in the room is Madback versus Farmington Hills, an opinion authored by Judge Godola. Because this case is recent and because Judge Godola is sitting directly in front of me,
Careful
I'm not
now.
going to argue the law.
Okay.
Obviously, I'm happy to answer questions, but I will make a brief reference to his opinion. I don't quite understand why it was only determined to be publishable in January when it was issued in 2023, because it was authored by you, Judge Godola. So I thought it would necessarily be published. But no, I didn't mean it that way. I wasn't trying to suck up. I thought all signed opinions were published.
All of mine should probably be published. They're that good.
Okay, I guess I don't understand the criteria for publication.
I'm not sure we do either, but go ahead.
Moving on. There's some doubt as to where the accident actually took place. It won't turn out to matter, but there's great debate in the briefs. But if you look at the deposition testimony, you'll see that, oh, it was for the potholes. Oh, it was where the strip was removed. Oh, it was a combination of all four potholes plus the strip. I don't really care. The notice referred to the stripped down asphalt, which is in the picture at page 10 of my brief. So this turns out not to be critical, although from the briefs you might think it is, but it isn't. What matters is the statute, and what matters is the statute that demands a notice, and what matters is the notice. The notice is at my brief, page 13, and you take the notice, and then you take the explanation of what that means, which is set forth at my brief, page 15. And this will be my only quotation of law. The opinion is in fact citing Plunkett versus Department of Transportation. And it says, the principal purpose to be served by requiring notices, principal purposes are to provide the governmental agency with an opportunity to investigate the claim while it is still fresh and remedy the defect before other persons are injured. So it's a pragmatic purpose. In 2 minutes, the city could have determined the exact location because the notice said the intersection of two streets. I think it's Field and Hendry. Yes, it is. Field and Hendry, 2 minutes to find this on the internet. If you're a 10-year-old, probably 30 seconds. It is impossible to take the position that the notice was ineffectual in giving you the location of the accident. Page 10 of my brief shows a picture. And the picture shows that it's right there. It's at the intersection of the two streets. It's not near an intersection. It's not down the block. And it's not, I could show you if you would let me walk you over to it. It's there at the intersection. You can zero in on it right away.
If it makes you feel any better, Mr. Shaw, I think this case is easily distinguishable from Madback. So
it makes me feel very bad, Your Honor. So I'm almost done, by the way. This is going to be a quick argument. There it is, the intersection. That's it. That's our argument. There's no requirement of pictures. And I should tell you that reading my brief, I'm not pleased with it. The brief focuses on potholes. And of course, I didn't know that I was going to be arguing in front of Judge Godola and this panel. So I could have eliminated probably 8 other references to other opinions. But the focus on the potholes is a genuine distraction. So what? There's nothing in the notice that's, there's nothing in the statute regarding notices that says attach pictures. Nothing there. We're not required to attach a picture of the strip of concrete that was removed where the accident culminated, perhaps hitting 1, 2, 3, 4 potholes and then hitting the strip and falling off. There's no requirement of providing that picture. The notice was perfectly clear, the intersection. The brief could have begun and stopped right there. We have to tell you where it was. We have to tell you what it is. We did. And the judge got it wrong, probably because, like me at the appellate level, the lawyers at the trial level focused on pictures of potholes. And therefore, the judge said, and so if the city gets the notice and they have pictures of the potholes, that's what they're going to investigate. Well, no, they should have investigated what the notice said. It said a stripped down piece of concrete at the intersection of 2 streets. That's what they were required to do. That's what they should have done. And the judge, with the help of the lawyers, got it wrong. And I didn't do so well on the appellate brief, but I hope I've clarified it. If there are no more questions, I'd like to reserve a couple of minutes for rebuttal.
I think you did just fine. Any other questions for Mr. Shaw? No, thank you. You have time for rebuttal.
Good morning.
Good.
My name is Linda Fagans, appearing on behalf of the city of Detroit. Well, one thing that my great colleague here was a great writer, and he knows how to present his cases.
Mm-hmm.
We agree on that what matters here is what the statute says. And how does this case line up with the statute? Yeah. And yes, when I saw that you were here today, I said, true. But let's start off with my first argument. My first argument is, and it's a little easier, the statute said you must state the nature of the defect and where its location, but it also mentions the fact that you have to address who the witnesses are. Plaintiff's notice was void of that. First of all, he lists 3 houses. One of them was an open field. That's not the name of identifying witnesses. Number two, it comes in his deposition that there were people standing around, and one of them was a man named Sean, whom he talked to later and got his telephone number. His name was never placed in the notice. His name was never added once, or even added or changed. So this itself is a ground for the judge to have granted summary judgment. If you read an argument too, that the failure to identify witnesses in a notice of claim is grounds for summary disposition. I cite the cases. Talk about a cold fish here. The failure of the particular plaintiff, although it's in a published case. And we can't help because you all issue unpublished cases, that this person did not even identify the son and the granddaughter. I didn't even mention that even though the plaintiff's wife and son were not actually there when he fell, the notice also implies that they saw the defect. He didn't even identify them, but I won't focus on that. This John, there's no witnesses. That itself is grounds for this court to affirm it. The issue was not whether you knew what they saw. Rarely when you're in an accident are you looking around to see what's happening. You're trying to recover from an accident or to protect yourself from an accident. The statute doesn't say that. It says what you know, and then it doesn't necessarily mean that you know everything of what they're going to say. It says name them, and it didn't. Now let's get to what my colleague says, this idea about what happened when the notice here about the location of the defect. First of all, an intersection, in my cases I cited in my brief, does not tell you where the defect it is. It's 4 quadrants. You don't know whether it happened in this corner, that corner, or where. And then in this particular case here, one could have got lost by the potholes, but they didn't get lost by the potholes because the deposition of the plaintiff here on page 2 of my brief, and I cited Exhibit C, pages 57 through 61, clearly says where he said what was the actual cause or where he fell was this, what they called a cutoff. Mm-hmm. And the cutoff was on field. All these potholes were what? On Hendry. So it clearly, the accident did not cover, it didn't show you where it was. So that shows that he did not identify what the defect was, the exact location. Intersection, potholes, pictures, it's not disputed here that they were all on Hendry. That fall, that cutoff was on the field street here. And the thing is, there's no such thing as substantial compliance. Yes, it was a bad accident, but as he said, started off saying, it's what the statute says. No one has overruled the Supreme Court. You can't say whether there's no concern. The issue of prejudice does not apply here. And in this particular case, because the Supreme Court in McCannon also said this. So our position is it was not sufficient. First of all, you don't know what the exact location was. The plaintiff himself admitted that where he fell was on near field where did your motorcycle end up the street view of Hendry and Freeman? Can you identify it? He said at this corner. And then when she mentioned where it was, that corner was where the strip was, again, was on field here. So in our position is we had no notice here. Yes, the purpose under the statute is to allow the city to know where the location is so it can find it and really to remedy it so no one else is here. But we don't have to do plaintiff's investigation for him in terms of looking for witnesses or for us to terms of search for where's this defect is location. Is it at that corner over there of Hendry and Field, or is it down here, or is it on a completely different separate street? these potholes led us astray. Those potholes, and to be honest, they were big enough. If he would have fell in that, it would be a much easier case, but he didn't. And there's no evidence of that. I want to know if I was going to say the church, forgive me. I'm joking. Do you have any questions of me, specific questions?
Any questions from Ms. Fegans? I don't think so.
Okay.
I
So,
think
and
we
I want to say that
understand.
in terms of Madback doesn't help plaintiff's case if you really look at it from our position. But I don't think you're going
Clearly, it doesn't help, but I don't know that it hurts either. So
well, and the argument that you really argued that you supported substantial compliance, I would disagree.
Okay.
Because it doesn't exist.
All right. Thank you. Any rebuttal, Mr. Shaw? No? Okay. Yes. Okay. That was a yes. I thought it was a
The
no.
trial court did not rule in favor of defendant on the basis that there was a failure to list witnesses, just to be clear. And on page 20 of my brief, I referred to Millot versus DOT. The relevant witnesses are those persons who witnessed, in quotes by the court, the occurrence of the injury and the defect, pertinent knowledge having to do with the accident. Notwithstanding that initially the notice thought, well, we think there may have been some witnesses, but there weren't. There were no witnesses. And that's why the judge saw no defect on any putative failure to list witnesses. Thank you.
Thank you very much. Appreciate your arguments and for your appearance here today. The case is submitted. Item 9, docket number 372054, Yolanda Williams versus Carl Rogers.
Morning.
Morning.
Afternoon.
Daniel Steele on behalf of the plaintiff appellant. I'd like to reserve 5 minutes for rebuttal.
Sure.
Thank you. And first, I did want to point out that I did file just yesterday, a statement of supplemental authority. It's a case that came out end of October. It is 5 weeks old, almost 6 weeks old. It is a significant case to the statutory claim because it says that with respect to the landlord's duty pursuant to statute, there's no notice requirement that has to be satisfied. So to the extent that the trial court did rule on the notice issue, I would say it does not apply to the statutory claim. Next, I wanted to move, and I will be brief. The significant error that I believe occurred below was that the trial court held that there was no contract to burden the landlord with the duty to repair as set forth in the restatement. That the court felt that the lease did transfer that duty set forth in the restatement, transferred it back to the plaintiff. I don't think the record supports that. The trial court looked at the first two sentences of the maintenance repair portion of the release and specifically cited them in his opinion, or his ruling from the bench rather, but then didn't go on to the rest of the maintenance repair section, which made clear that there were only certain circumstances where the tenant would be responsible for maintenance and repair, but then was very specific in saying those circumstances were situations where the tenant had caused the need for the maintenance and repair, which there's no claim that that was the case here. And that's why I believe there was error below. Furthermore, the testimony from the landlord is clear that he agreed that it was his responsibility to do repairs such as the cabinet repair that injured the plaintiff. That's significant. The language of the restatement does refer to either a covenant to repair or otherwise. So clearly we have an otherwise situation here where, one, I do believe that the lease does leave the responsibility for these types of repairs with the landlord. And secondly, the landlord admitted that was the case in at his deposition. The other points I'm going to rely on my brief. If there's any questions, I'll be happy to answer them.
Any questions?
I had one question. I have one question. Let's say I disagree with you on the premises liability argument. I agree with you on the statutory claim.
Mhm.
And I agree with you on your supplemental authority that notice is not required.
Mhm.
So my question is under that circumstance, it would have to go back to the trial court on the statutory claim.
Yes, yes.
And what I'm wondering is whether we should remand it back for the trial court to decide whether the amendment to the complaint would be futile.
Mhm.
And I imagine part of that balancing test, and this is where I'm turning to you and I'm going to next turn to the appellee. Would the trial court then evaluate whether the cabinet was fit for its intended purpose or not kept in reasonable repair in determining whether the amendment would be futile or not, or should we, and I think you'll say we should do it,
Mhm.
should we order the trial court to amend the complaint to add the statutory charge? So I'm wondering, in terms of a remand, if that's what we end up doing,
Mhm.
would we make the decision, or would this be a decision that should be left for the trial court to make?
I think that this court can make the decision. I think that the fact that the cabinet fell when it shouldn't have is evidence that he had not complied with the statute. It fits within the language of the statute regarding the landlord's obligation to make reasonable repairs.
Isn't there another question that involved in this statutory claim, which is that defendant would argue that the statutory obligation had been contracted away. And so, the question being, can you contract away the statutory obligation as purportedly was done with this lease agreement? Isn't that a question that should first be answered by the trial court?
I think it can be answered. Well, it should first be answered by the trial court, although I think that it's clear, just as with the negligence claim, the premises claim, there has to be some evidence that the obligation was contracted away. And here, I believe the evidence is clear that the obligation that the landlord had under the statute was not contracted away. And again, obviously the landlord admitted that. He said, yeah, it's my obligation to fix these. And I believe the lease language also supports that conclusion. And the other point that I make in the brief, and I'll fit it in here also, is it originally was a lease for a year, but then she carried over and it turned into a month-to-month lease. Not in that situation, Your Honor, you can't contract the obligation away under the statute. It says it has to be for a lease. If it's a lease of less than a year, you can't contract away the obligation. So again, that's why I think this court can rule as a matter of law, they remand it. And I believe it should be remanded on both the premises and the statutory claim. Again, if there's no more questions, thank you for your time.
Nothing further. Thank you. You have time for rebuttal.
Good afternoon, Your Honors. Nicolette Zachary on behalf of defendant appellee Carl Rogers, and I'm going to apologize if I break down into a coughing fit. I am not actually sick. I finished my antibiotics, but I have this residual cough, and it comes upon me, especially when I'm talking unexpectedly. First, let me ask, does the panel have any questions for me before I get into my arguments?
No.
Okay. So excuse me. In response to plaintiff's arguments, first of all, I want to respond to the last thing first in terms of the landlord tenant statute, and which provides that if the lease is for at least a year, you can modify the requirements of MCL 554-139 essentially, and that those can be placed, transferred essentially to the lessee. The fact that it's a holdover and essentially becomes a month to month does not negate the fact that it was a lease for at least a year, and the same terms would apply at the time that the contract was executed. So you can contract those away. However, first and foremost, MCL 554.139 was not pled. So the main argument before the court that has been appealed is the issue about possession and control. And this was a condition inside the lease premises. The tenant had under the lease, exclusive possession and control of those premises within the boundaries of the lease premises. And as such, defendant Carl Rogers did not have a duty to maintain within the leased premises. And the fact of the matter is she never reported the issue to him, this specific issue. Apparently she has problems with cabinets falling, even at different residences that she's lived at.
Seems.
I'm not sure why. I'm not sure how heavy those dishes are that she's been putting in them, but regardless, the trial court properly ruled that the defendant did not have possession control of the lease premises and therefore did not owe a duty in premises liability. The issue about ordinary negligence was not appealed, so that's not before the court. Now, getting, as I mentioned, as to the statutory contractual issue under MCL 524.139 that was not pled. Your Honor did mention about asking about whether or not, if you agreed with that issue should be, was a valid claim, that whether it should just be remanded for the court to determine whether leave should have been granted or should be ordered, the leave should be granted. However, and this gets back to where I started my argument, is basically, it's an issue of law. First of all, the notice issue that just came, that was just filed as a supplemental authority yesterday, excuse me, an application for leave Supreme Court has been filed and is pending. So that technically is not a final decision in terms of being binding on this case, even if it's a published decision. Respectfully to the panel, and I don't recall who the judges were on that panel. I believe it was a wrong decision. And I will tell you, and I don't think it's relevant in this case because of the ability to modify the lease provisions, which I already discussed under subsection 2 of MCL 554.139. That was done within the lease. The fixtures are responsibility of the lessee or the tenant in this case. And that really makes any issue of notice kind of immaterial. However, the flaw that I see in the is the name of that case that just came out.
McNeil,
excuse me, I'm sorry. I had to pull it yesterday. I hadn't seen it till yesterday. The McNeil case, the panel says that, well, MCL 554.139 does not explicitly contain a notice provision. And then they go on to discuss about inspections that were done. Well, MCL 554.139 does not include an inspection provision either. And the language in the statute talks about reasonable repair. It does not impose any sort of a strict liability. And just as one might argue that having to inspect would be somewhat inherent in a landlord covenanting to keep the premises in reasonable repair, an inspection is not find every little thing within get our magnifying glass out and explore every little inch of every place. It's a reasonable.
Also, the question before us has to do with whether or not plaintiffs should have been permitted to amend the complaint to add the statutory claim. And they asked for that relief. Plaintiff asked for that relief in the trial court, and the trial court never ruled on that request. So my question to you would be, set all the substance of it aside, why shouldn't it go back to allow amendment of the complaint? Now you won't know who I am.
Nope, I see you right here. Because under MCL 54.139 subsection 2, the plain language of the statute says you can modify the lease. The lease was modified, and the issue of whether or not leave should have been granted, it's a question of law. And if it was futile, in the interest of justice and economy, even though the court didn't specifically address it in the trial court, to go back and tell him, okay, now you got to say whether or not you should have denied leave. Deny leave, we come back here and we're in the same situation. But the fact of the matter is any amendment would have been futile, and whether the trial court expressly addressed it or not in its ruling, it implicitly denied leave because it didn't permit an amendment.
Doesn't McNeil, though, undermine your argument about futility, whether you like the outcome or not? It says what it says, which is no notice is required under the statute.
Well, respectfully, no, it doesn't undermine it, because under the plain language of the statute, subsection 2, the covenants and requirements under subsection 1 can be modified, or maybe it's subsection 3 now. I can't remember. Is it 2? Okay. They can be modified by the lease, and the lease modifies those provisions regardless of notice. So it's an argument independent of whether or not notice applies. And as I said respectfully, I think that McNeil decision is incorrect. Given that it's an issue that is a significant departure from what has been followed in the law on this issue in the past, I expect Supreme Court will grant leave on that. But I don't think it's pertinent to the case today.
I wouldn't hold my breath on that one.
That they will not
grant leave. I think we understand your arguments. Do you have anything else you need to share?
I will rely on my brief, and I apologize for the typos that I noticed this morning.
No problem. All right. Thank you. Any rebuttal, counsel?
Very briefly. I just point out that the section 2 of the statute does say the parties to the lease or license may modify the obligations imposed by this section where the lease or license has a current term. So I think that extinguishes the argument.
Yep. Got it.
Okay. And last point, again, it says modify the obligations. That can be done either in writing in the lease, an addendum, or the landlord saying, we're going to take care of this problem for you, which is what happened here. He took care of the cabinet problem in the past. He testified that it was his obligation to do it this time. Thank you.
Yep. Thank you. Appreciate your arguments. The case is submitted. All right. Item 10. Docket number 371451, Elise Williams versus LGC Global Incorporated.
Good morning, Your Honors. Zach Runyon on behalf of plaintiff appellants, the estate of Williams. This is a really tragic case. The plaintiff in this case was involved in a house fire. He was disabled. He was unable to remove himself from the house. And at the time of the fire, the city of Detroit was replacing a water main in his street, which rendered the fire hydrants on his street inoperable. Shockingly, nobody informed the Detroit Fire Department about this. And so when the fire department was called and they tried to extinguish the fire, they hooked up to several fire hydrants that didn't work, which by their estimation caused a 6 to 8 minute delay and resulted in Mr. Williams burning alive. And so
so you argue.
Well, and I was just about to get into that. When this motion that we're here for today was decided, it was just based on the complaint in the pleading. So, I mean, at this point, I think the court has to accept that that is what happened because that's what we pled.
Right.
And just to explain a little bit of the procedural posture, the reason there are some depths in this case and there is some discovery that happened before this motion is because the plaintiffs originally sued two private entities that were contractors involved in replacing the water main.
Right. They settled out, right?
After this motion was decided, and I think that was confidential, but they are out of the case now. But what happened was, and this was very surprising, is when we were taking depositions of the city of Detroit employees while the two private entities were the only defendants, the city of Detroit basically took entire blame for what happened. Suresh Patel, who's the individual defendant at issue, said, yeah, it was my responsibility and my responsibility only to put cones on the fire hydrants to notify the fire department that the fire hydrants were inoperable. And he said, I didn't do it. He had no excuse for why he didn't do it. And he even went so far as to say is the reason I do this is so the fire department doesn't try to hook up to these fire hydrants in case there is a house fire. And he even admitted again that if he didn't put the cones on, he knew that a risk of that was somebody would die in a house fire. So after that testimony, we filed an amended complaint, added City of Detroit and Suresh Patel. It was in response to the complaint, or I should say, I guess in lieu of an answer to the complaint, that the City of Detroit filed the motion to dismiss under C7, C8. And unfortunately, I don't really know what the trial court's reasoning was for dismissing.
Yeah, neither do we.
Right, which makes today a little bit more difficult because I normally like to focus on the reasoning of the trial court, but we don't really know what it is.
Right.
And
We
so
don't even know on which basis, because there were multiple arguments made as a basis for summary disposition.
Exactly.
So we don't even know which of the arguments, or one or both, that the trial court granted the motion upon.
Exactly. And so I know it's been a long day for the judges. I don't want to.
We're going to be here a lot longer.
So I don't want to just go scattershot with my argument. If
Right.
there's a particular area you want me to focus on, please let me know. But I do think this is a fairly simple issue given the timing of when the case was dismissed. When you have an individual who is saying that he knew his failure to put cones on the fire hydrants could result in death, I think it's impossible to say that there's no factual development that could show his conduct amounted to gross negligence. And as far as to the causation element, the only argument raised by the city and Suresh Patel in the trial court was that the proximate cause had to be the fire, which Ray versus Swagger says is not a correct analysis, and you can't blame non-human factors and make non-human factors the proximate cause. In the Swagger decision, they actually say specifically a fire cannot be the proximate cause.
I happen to think that's not a holding of the Supreme Court in Ray v. Swagger. So it was sort of an interesting thought bubble by Justice Viviano in that opinion, but it had nothing to do with facts in Ray versus Swagger, which involved human actors exclusively. There were no natural causes at play there. So,
well, at the very least, it provides an explanation or a basis of how these cases should be analyzed. And they say in the opinion, even setting aside the comments about non-human factors, to determine what the proximate cause is, you weigh the cause of each of the involved actors, which would mean you have to weigh the human actors involved in causing the injury. And in this case, there's no evidence that anybody did anything wrong other than Suresh Patel, because it was his responsibility to put the cones on. And so again, the defendant wants to argue a lot about the but-for cause, but at that point in discovery, it was too early to make that decision.
Right.
And so, and as far as the constitutional claim, I understand what the current state of the law is. I do think, given the opinion in Bowserman, that the Supreme Court should take a second look at, or I think it may be the first look since Bowserman, of whether or not constitutional claims can be made against municipalities. Justice Viviano, in his dissent, even said that there's no reason to believe the decision would be any different or should be any different with regard to municipalities. So, I won't go too deep into that, but I just wanted to preserve that issue. And unless there's any other questions, I'll rely on my brief.
Any other questions?
Thank you.
No.
Thank you. You have time for rebuttal.
Good afternoon. Oh, my goodness. Might be catching what the council had.
Sitting a long time without talking will do that to me.
Correct. But good afternoon, your honors. Good afternoon to your staff. May it please the court. My name is James Boudreau, and I'm here on behalf of Appellee City of Detroit and Mr. Suresh Patel in this case. And today we request that this court affirm Judge Gillis's decision in granting Appellee's motion.
What was his decision?
Yeah, how do we do that?
Other than
So-
to grant your motion.
So yes, the order and the precipice that he signed was concise. I'm in complete agreement with that.
That's putting it very kind.
But what I will say is he had every right to do what he did. And I do think that issue, I understand that and respectfully understand that he brings it up today, but that's never been an issue that's been outlined in the briefing on this appeal. And I think that's more of an abuse of discretion issue that I don't think is up for appeal here today. But to answer your questions about, why he did what he did, I can't speak for Judge Gillis, but under Michigan Court Rule 2119E3, he can proceed without oral argument. And then there's an understanding that he's read the briefings and that he understands what's been submitted. And I don't think there's been anything that's countered that.
It seems to me, though, counsel, that there is no way for this court to undertake analysis that is required by law when there's a box checked on a precipice order. I know you don't have control over that, but I know there was a subsequent order entered. And would there be any reservation by counsel to insert the language necessary, which would then allow us to undertake the appropriate analysis? I mean, I get when there is no oral argument. I mean, we all know, right? As litigators, you bring the order you want entered and you bring an alternative order or a blank order so that the court can sign off that day. That didn't happen, but there was a subsequent order. So why not help the cause so that there is the ability of this court to undertake analysis?
To answer your question, Your Honor, I do think that this court has the ability based on that subsequent order that was submitted.
An
Because
issue of gross negligence where there is no analysis? How?
Because of how high that standard is, Your Honor, that the standard of gross negligence, and it's outlined in cases that this court has held, that in order for an employee to be grossly negligent, and this is really just focusing on Mr. Patel, so I understand that there's the issues with the city of Detroit as well. But as it relates to Mr. Patel, in order to establish gross negligence, you need to establish that he owed a duty. You need to establish that the conduct that he committed was so reckless to demonstrate that he had a substantial lack of concern of whether an injury resulted. And then you have to establish causation and the proximate cause analysis, and that's both but for and the actual proximate cause. And that standard is incredibly high. I respectfully, I don't think any more was needed because of how high that standard is and because of how, based on the undisputed facts, it's clear that that standard was not met. It's clear. And I think the record shows that, and we're not disputing the facts, although I will, just for the record, I understand that Mr. Suresh Patel did, I'm not disputing his testimony and what he said, but understandably, it was omitted that Mr. Patel did call the dispatch center that he was supposed to call that morning of the fire, notifying exactly which fire hydrants would be out, exactly where they were. And mind you, those fire hydrants were not the closest fire hydrant to the house that was in operation. And then in addition to that, when the fire did start, Mr. Patel ran to those fire hydrants that the fire department was originally trying to connect to let them know, along with the other contractors, to let them know that those fire hydrants were out of service. And I think that goes primarily to the gross negligence portion of that analysis. And if an objective observer watched that, would that demonstrate that he did not have had a substantial act of concern about whether an injury resulted? The answer is no. Just based on the law, based on, and Judge Rick, I know that you opined the Dougherty case that we cite in our brief, but based on Dougherty, based on Woods v. City of Detroit, based on a number of cases, Tarley v. Crabtree, that standard was not met in this case. And what I will say to it in response is the proximate cause issue here is also something that appellants have not even argued on this appeal as it relates to whether Mr. Patel's conduct was the most immediate, direct, and efficient cause to the unfortunate death of the decedent in this case. And the answer is no. There is an unrefuted, undisputed report opined by the fatal fire investigator that investigated this, and his determination found that the fire was untenable prior to the fire department even getting to the house and getting to the original fire hydrants that they tried to get to. It's clear, and that hasn't been disputed. And then in addition to that, and it's unfortunate, any case involving a death is difficult, and I'm not disputing that. But what I will say is Mr. Williams was a bedbound individual, and on the date of that fire, unfortunately, he was given a lit cigarette in a room that it's, again, undisputed, that had poor electrical maintenance, and then the fire resulted. And based on that fatal fire investigator, refraining from careless smoking would have prevented that fire. And again, it was untenable even prior to the fire department getting there. So that as it relates to proximate cause, Mr. Patel's conduct could not have been the proximate cause or even the but-for cause in this case.
And can I ask you about the order and the state constitutional law claim?
Yes, so I understand that the order does not address the state constitutional law claim. What I will say to that is Bowserman is clear, and Justice Viviano's footnote in his dissent did make clear that they were not going to get to whether municipalities are impacted by that Bowserman decision. And even since then, there has been unpublished cases that have come out, and at that point when the briefings were submitted, those were the only authority as it relates to that issue. And both of them in those opinions stated that Bowserman didn't get to whether municipal employees whether there's damages, forgive me, I'm misconstruing it a little bit, but whether those plaintiffs in that case are entitled to damages based on a constitutional violation. And in those unpublished opinions that came out subsequently, it outlined that because Bowserman didn't get to it, we're not going to get to it either, because municipal employees, that hasn't been analyzed yet about whether that will apply to them. And for that reason, the law is clear that at least at this point, there's no binding authority stating that the government employees, municipal employees, there's state law remedies to that. And then further, I will just reiterate in Bowserman as well that based on the understanding of that opinion, that remedy is if there's no other remedies available to the plaintiffs. And in this case, there is, and I understand I'm arguing against the other remedy, but there is additional remedies here that could be sought, and that would be under the GTLA, and I would fully argue against it, and I have today and in our briefing. But yes, that's a long-winded answer to your question, but I believe the law is clear on why it should prevail there either.
So it's up to the appellate court then to conduct the proper analysis when the trial court doesn't consider it?
I respectfully, Your Honor, I do think as it relates to the trial court, again, I can't speak for the Judge Gillis, but he read the briefings and when the party submitted the briefings on the issues and issued his order. And based on that order, I would say yes, that the Court of Appeals does have the ability to review that and review the underlying law, especially given that this is a de novo review and the ability to review the record at hand. And so, yes.
Okay.
Yeah.
Anything else, counsel?
No, Your Honor. I'm all good. Thank you so much.
Mr. Runyon?
Thank you. I'll be very brief. The the argument about duty, the only arguments raised in the brief saying that Suresh Patel did not have a duty to my client relates to the idea that there had to be a special relationship. And that's just not true in this case. The special relationship analysis applies to when an individual has an affirmative duty to act. And that's not what we're claiming in this case. We're claiming Suresh Patel in performing an undertaking of cutting the water supply to several fire hydrants, conducted that in a grossly negligent manner by failing to put the out of service cones on the fire hydrants. And I think, defendant's argument that you can't find Suresh Patel grossly negligent because after the damage was done, he tried to, help the fire department find a hydrant that worked. It's too little too late. To me, that even shows, more evidence that he was grossly negligent because he knew how dangerous it was to leave those fire hydrants without the out of service tags on them. The reliance on the report from the fire department related to the fire investigators' findings, I don't think that should be considered at all in this case for multiple reasons. One, the report itself relies on hearsay because many of the conclusions reached by the fire marshal were based on statements of witnesses based on their description of the size of the fire and how long the fire had been going before the fire department got there. Those witnesses are unidentified. The statements were not under oath, and we never had the opportunity to depose these people because the case was dismissed on the pleadings. We have the ability to retain our own expert to create an issue of fact on, the conclusions of what caused the fire, and B, did the delay result in our client being killed by the fire. And so again, if this was a C-10 motion, I think the analysis would be very different. At this stage, it's just too early to consider that report. As to the Bowserman analysis, this really does fit squarely into the exception that Bowser discussed with constitutional claims, because there is no other remedy against the city of Detroit for what happened. And the GTLA does not provide the plaintiff in this case a remedy against the city of Detroit. It only provides a remedy against an individual for grossly negligent conduct. It doesn't provide any remedy whatsoever for a constitutional violation, especially against the city of Detroit. And that was the exact same scenario that the Supreme Court analyzed in Bowserman, and is why the Bowserman court said we need to have remedies for constitutional violations, or the Constitution has no force behind it. They're just, I think, hopes and wishes that the government will abide by the Constitution. So unless there's any other questions, I'll rely on the brief and ask that the court reverse Judge Gillis.
Any other questions? All right.
Thank you.
No, thank you.
Thank you.
Yeah.
Just
Judges.
Judges, sorry. I just want to say, I think I have a duty of candor to bring this up and respectfully.
Okay, given that lead in, you're not entitled to a rebuttal, but given what you just said, I'll let you approach and address the issue of candor. I'm going to forget who I am.
Okay. I only say this because I don't think there's been any notice of supplemental authority submitted, but there was a case earlier this year in May that was that went through the GTLA gross negligence analysis. It's Flint or Cooper v. City of Flint. And in that, the Clark v. Dallman case was applied. through the duty analysis.
That's, now you're getting rebuttal.
So,
So,
well, no,
all right.
and I'm just gonna say that
Okay.
authority's out there.
All right. Thank you. Case is submitted. Thanks for your arguments and your appearance here today. We appreciate it. All right. That brings us to item 11. Docket number 371-159 CA Incorporated versus General Motors Holdings LLC. Just note, we're in the General Motors building. I know we call it Cadillac Place now, but it'll always be the General Motors building to me. And this building, I'm from Flint, and Billy Durant he led the Buick Motor Car Company, the Chevrolet Motor Car Company, and General Motors twice. And this building, yeah, he became penniless virtually. He was running a bowling alley in Flint, Michigan when he died. And he was the CEO of General Motors when this building was constructed. And if you look up there in the corner of the building, the shades are obstructing it, but you'll see a letter D on the cornice. And that is because of Mr. Durant. And they considered naming this the Durant Building. And I think he was not in favor of that himself. And so it became the General Motors Building. So just thought a little point of interest. I learned all that stuff from my father. So, okay. All right. You may proceed.
Good afternoon, Your Honors. My name is Allison Plessman, and I'm here on behalf of CA Inc. Just at a common sense level, this case is really about CA and GM reaching an agreement and pricing based on a volume discount. And what GM is essentially trying to do is get out at year 2 when it received the benefit of 3-year pricing. And so this appeal, though, turns on straightforward contract text that the circuit court just got wrong. And in 2020, the parties replaced the prior in whole and in part language that was in the 2015 license agreement. And they expressly agreed that GM could terminate for convenience without further charge, but only if it collectively terminated the existing agreement as collectively defined, and not merely a single order form. And what GM did was when it terminated in 2022, after 2 years of the beneficial pricing, they tried to terminate the 2020 order form only and the associated purchase order. And there was only one of them, and I'll get to that in a minute. And then what they tried to do is leave the rest of the licensing agreement and all the other order forms in place. So essentially getting out of the payment, but keeping the rest of the agreement and its benefits in place, which is exactly what the parties contracted to avoid. Now, the circuit court's ruling hinged on treating the disjunctive, geez.
Say it 10 times fast.
Yeah, exactly. Term or. It's really is, after listening to all of this great argument, we're talking about the word or today and whether or not that should be given the undue weight that we believe that it was. And basically the courts focused on the word or and ignored really important contextual other text in the agreement and rendered it meaningless, which of course you can't do. And so at a minimum, and now we think that if you go through the contractual provisions, and I'm going to do that in a little bit of detail, hopefully not too much, because I know this is a long day. I think when you go through the contractual agreements in detail, you can only reach one conclusion, and that is that the parties agreed and their intent was not to allow piecemeal termination, but to terminate this collective existing agreement. But at a minimum, CA's agreement is a reasonable interpretation of the contract. And so when you have two reasonable interpretations, the result is not dismissal under C8, but to allow further factual development, which of course, as alleged in our complaint, we believe, again, only supports our reading of the contract. So I want to start with the 2020 order form. And if you go to the termination for convenience provision, it starts out by saying that the termination for convenience clause in the 2020 order form expressly supersedes section 5.3 of the CA and semantic license agreements. And then it defines the termination right and the existing agreement collectively. Now, the way that existing agreement is defined as it says collectively is that GM may terminate the agreements, this order form, together with each and all purchase orders or any order forms or other ordering documents without cause and without further charge or expense. Now, if you go back to the 2015 license agreement, section 5.3, and you look at the language that it's amending here, that language specifically talks about how GM reserves the right to terminate this agreement in whole or in part. And another thing to note that might not have been as highlighted in the briefing, in this 5.3 provision, it also says even though they can terminate in whole or in part, GM was still on the hook for all the rest of the payments. So that was always the understanding, that even if they were allowed to terminate in whole or in part, they still had to pay. They didn't get out without further charge. And so what happened in 2020 is CA actually gave them a little bit. They said, okay, you can terminate for convenience without further cause or without further cost or charge, but only if you terminate the entire existing agreement. And so basically what they did was take out that in whole or in part, but they gave them a little bit too. They said, we're not going to let you terminate in whole or in part at all, but we will let you terminate without further cause or without further charge, as long as you collectively terminate that existing agreement as defined.
Aside from striking out in whole or in part, how does the 2020 agreement to be read as saying you have to cancel everything or nothing at all, which is your position? Because I'm frankly not seeing it. I mean, again, you put up a lot of contextual arguments. The first one of which I think relates back to the striking of the in whole or not striking, but the failure to use the in whole or in part language in the 2015 agreement and the 2020 agreement. It seems to me that the termination language in the 2020 agreement is saying the same thing, only using a lot more words and, more, or put maybe in a better light, more specific language.
Yeah, so if you look at the provisions as a whole in the agreement, you can see that when the parties wanted to specify that any order or any agreement could be terminated or any license, they said that. And they could have very easily just brought over the language in whole or in part and left it. They decided not to, and you have to give effect to that deletion. If you don't, that deletion had no meaning, and that can't be the case, because if it, under GM's reading of it, they're essentially keeping in the in whole or in part language, and that was taken out.
It's very broad language. GM may terminate the agreements. This order form, let me start over. The agreements, comma, this order form, comma, together with each and all purchase orders or any order forms or other ordering documents in effect as of the date of termination, without cause and without further charge or expense.
And so what the parties were trying to capture is that any of those things all of those things would need to be terminated as part of the existing agreement. There would be no reason to collectively define it as the existing agreement. And then later, if you look at the second paragraph, it says, if the existing agreement is terminated without cause, neither party shall have further obligations. So it's assuming that that collective definition of existing agreement is captured. And the reason for listing all of those things out is because what you're trying to capture is what is the existing agreement? What is the agreement in place at the time that the termination for convenience is being affected? Because this is an amendment to the license agreement. So this language could be in effect after the 2020 order form has expired. And so what it's basically saying is it's a catch-all. It's trying to catch everything that could be in existence at the time that whatever is existing at the time that the termination for convenience is exercised.
Yeah.
And so it wants to be
I was
broad.
going to say your argument would be stronger if those ors were ands.
Right. And that's what that's the problem here. But to focus only on the or and not give any effect to the fact that in, for example, section 5.1 termination for cause, when they want to terminate only one license or any order, it specifically says that. In the semantic agreement, it refers to the termination of any license. It would be very, very easy to do that. And also, not only did they add in this collective definition of existing agreement, which must have some meaning, they also added in the language to gather with each and all purchase orders. So that's all of the purchase orders that at the time of the termination for convenience is exercised, those purchase orders that exist under the license agreements. Now, GM wants to say that the together with each and all purchase orders only modifies the 2020 order form. But that's not what it says, first of all. But also it makes no sense because there's only one purchase order under the 2020 order form. So then what does the each and all mean?
Ms. Plessman, maybe you can help me with something. I'm sorry to interrupt, but other than in the parenthetical at the very beginning of 5.3, collectively, the quote, existing agreement, where does that term existing agreement appear again with respect to termination?
So in the second paragraph in the termination for convenience, it says, in the event of a termination by GM pursuant to this provision, if the existing agreement is terminated without cause, neither party shall have further obligations. And so that's,
Thank you.
so it's again saying if that collective existing agreement is terminated, then you have no further obligations. Now, the trial court focused in this provision on the second part of that sentence.
Hang on a second though, because it then says, neither party shall have further obligations under the terminated portions of this agreement.
Yes. So
which seems to suggest that you can terminate subparts of the agreement, doesn't it?
So that's what I was going to say. So that was the next focus. The terminate, if you read the full sentence, says under the terminated portions of this agreement, not the existing agreement, the agreement as a whole, except for those provisions that survive termination under the agreement by their terms. And so what that's if you go back to the license agreement, there are certain terms that just survive by their nature, like confidentiality, for example. So you might have where you're terminating the existing agreement, but you might have certain provisions like the confidentiality obligations that, as it says here, that survive termination by their terms. And so that it's not saying that that you can terminate one order or, one license agreement or one portion of an order form. That's exactly what the parties were trying to avoid and why they amended the language in the first place. It's merely just saying that to the extent that there are provisions that survive just by their nature, which is what the sentence says.
How are we to know which ones survive and which ones don't?
So if you go back to there's a survival provision in the license agreement that defines and says that certain provisions are that survive the agreement. Termination generally, right? That survive the termination for any reason.
Okay.
And so that's what we believe that provision is focused on, and the circuit court ignored that last portion of the sentence that explains what that means, which is the survival of the terms. For any reason. Now, again, the court also focused on the term on page 5 of the agreement. There's an and or that the court focused on, and we believe that is not in any way instructive as to what the termination for convenience clause means. And that's because it's referring generally to any kind of termination. And as you can see from the license agreement, there are situations in the license agreement that anticipates that a single order or a single license agreement might be terminated, for example, in a termination for cause, or if there's delayed delivery. There are any number of reasons why in some situations, not termination for cause, a single order might have been terminated. And so that provision later on doesn't mean anything with respect to the termination for convenience, and the fact that the parties added collective definition of existing agreement and added the language each and all, and took out the language in whole or in part. And so our problem with the circuit court's order is it focused only on that or, but it ignored the fact that this provision was amended. It was amended to take out the whole or in part language. It was amended to add the each and all language. And so she's giving undue weight to the or language and ignoring the each and all purchase orders when there's only one purchase order, if it's only applying to the 2020 order form, and ignoring the collective definition of existing agreement. And there would be no other reason to give a collective existing agreement definition unless you intended, or unless the parties intended, to terminate for convenience the entire existing agreement. Now, it also makes commercial sense that that would be the intention. If you look again to the parties' understanding under the 2015 termination for convenience provision, it was always the case that if they terminated for convenience, they still had to pay, because that's important in the software context with this volume price discount. CA doesn't want to give discounted pricing and then allow the counterparty to just say, okay, well, thanks for the discounted pricing. Now we're going to get out early. So that was always the party's understanding. Now they gave them a little bit in the negotiated language in the order form, saying, okay, well, only if you terminate the entire existing agreement, there's got to be some consequence to that. And now, as a result of making that modification, CA is actually being punished for giving them that extra benefit, which, of course, if the court were to say that there was a reasonable interpretation both ways and there was factual development, the record is very clear as to what the parties intended and why that in whole and part language was expressly taken out. And so our position is that, again, the language is clear. You have to give effect to those changes, that specific language, and you can't just focus only myopically on the word or, but at the very least, there's two reasonable interpretations here, and a CA dismissal was inappropriate.
Any other questions for counsel? All right, you do have time left for rebuttal.
Thank you.
Good afternoon.
Afternoon.
May it please the court, Chief Judge Godola, Mark Maggie on behalf of GM. My intuition is that perhaps the court doesn't need to hear a whole lot from me. This is, after all, a contract case. The briefings are done, the contracts are in, the questions, I think, bring to the forefront of what we've argued about and what I would bring up. But I don't want to falsely assume that, and I want you to please ask any questions that may be a hang up. If there aren't any other questions, I think the main two things I heard a lot about that I would just briefly address are this definition of existing agreement, as well as taking out the in whole or in part. There was one comment by sister counsel, and as an aside, no offense to counsel here, I've not had the pleasure to make the acquaintance. I was kind of looking forward to seeing Justice Wilder, so unfortunately he's not here today, but
I'm sure she will give him your best.
Yes.
And ours.
Yes.
As our former colleague.
But there was a comment about this being a catch-all to encapture what is the existing agreement at the time. I completely agree with that sentiment. You've got a provision where you're talking about different things being able to be terminated at different times, and you're grappling with how are we going to define what's left, and what is left after any given termination is what is the existing agreement at that time. So I think that was a very apt definition for trying to deal with moving parts that may not look the same tomorrow as they look today, but tomorrow you know what you have is the existing agreement, which is minus anything that was terminated. And then as in terms of this removal of the words in whole or in part, If the court will indulge, I want to just share a quick anecdote. I was in front of Judge Redford and a panel in Grand Rapids.
My condolences.
Yes. Well, you'll see, it was condolences for me because
Okay.
I was arguing a case and I was making an analogy, and he said, well, that's not really the same facts here. And I said, well, I agree they're not apples to apples. And he jumped right in and he said, I'm not sure they're apples to rutabaga. And here I would say that comparing the in whole or in part to what we're trying to do with the new agreement is apples to rutabaga. And the reason is that in the 2015 agreement, you just have one agreement, and the parties are agreeing with each other. You can terminate it in whole or in part. That's very easy to do under in a single agreement. When we come to the 2020 order form, the very first provision says we're trying to supersede not only section 5.3 of the CA agreement, but we're also trying to supersede 5.3 of the semantic agreement, and we're trying to push everything in together. So I'm not even sure how I would include the in whole or in part language if I wanted to, once I have all these agreements, without being very clumsy about it, because it no longer fits. You have to come up, and I agree with Your Honor, Chief Judge Godola, we got more specific and more words out of the fact that we're dealing with more agreements. So now instead of saying in whole or in part, we achieve the exact same thing in the way that the parties have always operated, but now we're accounting for there being a defined term agreement, which now encompasses both the CA license agreement and the semantic agreement, comma, order form, and then applying the rules of construction that are well known. We're asking for an interpretation of this provision that applies commas and ors the way that all the case law says you do it, because there isn't anything about this contract that makes it, quote, dubious or leads to absurd results if you do it the way that the language is presented here. So I had other points prepared, but as I opened with, I really only want to take up more of the court's time with issues that are of concern to the court. So if there aren't any questions about our position, I would take a seat.
Any questions?
Yeah.
I don't think I have any either.
Thank you.
Thank you. Rebuttal, counsel?
Just brief, Your Honors. With respect to the semantic agreement, I agree that the language in the order form is intended to also amend that language. And I think when you look at that, the section 5.3 of the semantic agreement is just another example of how the parties clearly knew how to terminate only a single license, which is the language in the semantic agreement. It says any license, right? It's very simple. Again, in the termination for cause, it says they can terminate any license or agreement to which the termination for cause relates, right? It's not overly complicated to do that. And so when you look at the definition, you look at the other agreements where the parties have very easily in the past been able to articulate if the intention was to terminate only one part, or in whole or in part, or one license. They've done that. And here the intention, again, was to give a collective definition, existing agreement, and you have to give effect to that. In addition, counsel didn't address the fact that they also added the each and all purchase orders. And I think that's just a critical fact. If that language is added, it has to mean something. And I think that there is a way to harmonize the language to give effect to the existing agreement collective definition, the each and all purchase orders, and the or, to read it as just saying, this is capturing everything that might be in existence, because there might be an order form that's not called a purchase order in the future, which happens all the time. There might be an order form that doesn't exist in the future, that doesn't exist now, but it exists when the termination is happening. So we just want to make sure that the existing agreement captures whatever is in effect at the time. But there was a reason for the amendment. There was a reason for the deletion of the whole and in part. There was a reason for adding each and all. And there was a reason for making clear that the further charge would only happen if the existing agreement was terminated. Not when a part of it, but if the existing agreement as collectively defined was terminated.
Okay, thank you very much. Appreciate your arguments and your appearance here in court today. Thank you for the concision of your briefs. When I first looked at this, I thought, we're going to have 50-page briefs and reply briefs. And, it's really a pretty straightforward case, and you treated it as such. So the court appreciates that. All right. The case is submitted. All right. That gets us right now. Yeah. Okay. Well, before we get to item 12, we're going to take another brief recess and we'll be back in about 5 minutes.
All right.
Okay, sorry for the interruption. Item 12, docket number 374093, In re Delbridge Miners. We do have a waiver for the LGAL, I believe, is counsel for the appellant, Ms. Miller, present in the courtroom. All right, that will be submitted on the briefs. Item 13, docket number 374874, In re M.S. Stallworth Minor. Again, Ms. Miller not checked in. Oh, could have just kept going. Item 13 will be submitted on the briefs. Item 14, docket number 374839, In re Durham Miners, Ms. Miller again, not checked in. Item 14 will be submitted on the briefs. Item 15, In re D.D. Robinson Minor, no one's endorsed, will be submitted on the briefs. Had I known this, we would have just plowed right ahead. Item 16, docket number 373936, People of the State of Michigan versus Nosaka Hare Anu Monu, I'll say it that way. Solomon Radner is endorsed on behalf of the appellee. You may proceed.
Thank you, Your Honor. Good afternoon, members of the court. My name is Solomon Radner. I represent Mr. Anumanu, and I'm very cognizant of the fact that I'm right now the only thing standing between all of you and your very late lunch.
Right.
So I'll make this even briefer than I otherwise would have. I know that you've read the briefs. There's just several points that I think are important to make because when I was reviewing my notes this morning and reviewing the brief this morning, I noticed that there's a couple of things that I really wanted to address. First and foremost, the prosecutor argued in her brief that defendant has never provided an offer of proof that this information was not known to his trial counsel. This is on page 26 of her brief. I was looking for where I can actually disprove that because I know it's easily disproven, and the strongest way to disprove that is with her own brief a little bit earlier on page 19, where she refers to the November 13th, 2024 evidentiary hearing during which defendant testified, and he testified that the October 2018 was the first time seeing the documents from that FOIA request. So there certainly was an offer of proof. A second point that I wanted to make was that the prosecutor obviously offers that there's no newly discovered evidence here, and that therefore that in and of itself is a basis for us to lose this appeal. The problem with that is that the court on December 13th, 2024 went through in great detail and explained every single piece of newly discovered evidence after multiple evidentiary hearings, after hearing testimony from both the defendant and the officer in the case. This is the first time I've ever had the recanting witness be the officer, and then made the determination that there was newly discovered evidence and it was prejudicial. She went through the entire CREST test and came out in our favor. The last thing is just...
I'm sorry, what officer? Officer
Ellis.
Ellis provided an affidavit, correct?
He wrote an affidavit. He also testified.
Okay.
Very briefly.
Okay.
But he did testify.
All right, thank you.
The affidavit, the new evidence, and obviously his testimony creates a massive hole in the prosecutor's case because the only piece of evidence in existence that connects my client to this crime is that glove. So if we don't know where that glove came from and where it disappeared to all the way until the year 2010, then obviously there's a big hole. And one last point, and then if there's no questions,
The glove
I'm done.
issue was raised in the post-trial motion for new trial and in the first appeal to this court, right?
As what kind of issue?
I don't know. You tell me.
Okay,
I'm the one asking the questions.
Okay, so it was raised, but not in the context of.
It's not new evidence.
It's not new evidence in and of itself. The fact that it didn't exist until 2010 is, because now we have testimony from the officer that it did not exist prior to 2010. And by the way, there's not a single police report prior to 2010 that mentions the glove. If there would be, the prosecutor would have attached it to her brief.
Did the officers testify it didn't exist? My recollection, and correct me if I'm wrong, was that no, I'm summarizing. No, I didn't submit the glove. Had there been a glove and had there been a profile, or had I had a suspect, then I would have submitted to the lab a sample of the suspect's profile and the glove. The fact that I didn't forward the glove tells me either we didn't have a suspect or we didn't have a glove.
Right. We didn't have a suspect's DNA.
Correct.
Or we didn't have a glove.
Correct.
Which we now know, thanks to this newly discovered evidence from 2018, they absolutely did have two suspects' DNA, Mr. Alley and Mr. Stewart. They did not know that prior to this newly discovered evidence in 2018. So that's why in that context, the glove is new. The glove itself is not new, but in the context of now there's real questions as to where the glove was and why it wasn't tested. Because let me back up. When the officer testified at trial, he said that there was nobody to test the glove against prior to them doing it in 2010, 2011 against Mr. Anumanu. The problem with that is that subsequently in 2018, we learned that they did have two suspects' DNA. They had Alley and they had Stewart all the way back in 2001 and never
Glove
tested.
match their DNA?
We don't know because they never tested
But
it.
it did match your client's DNA.
It did, but the
Okay,
question is
so,
where was it?
I mean, what are we doing here?
Where was the glove up until 2010?
Does it matter?
Of course, if it wasn't in the back of the police car, the office.
We have a photo of it in the back of the vehicle.
We have a photo.
That the victim owned, right?
Well, we have a photo from an officer claiming that it's in the back of a vehicle. We also don't have that glove mentioned anywhere in any police report. They list every single thing they find in the car. They list every single thing they send to the lab. In every single report, the glove is not mentioned. So yes, 15 years later, a picture shows up and they say, this glove in this picture existed 15 years ago. Then why isn't it on a single police report from the last 15 years?
Is there, in terms of a police report, that's one thing, but wasn't it part of a inventory is the wrong word, but is there a sheet that indicates that the glove was recovered from the vehicle? Not a police report. Is there a report?
Yes, and it's dated 2010.
So they did have the glove in 2010.
In 2010, they finally had the glove. The first police report that mentions the word glove is dated 2010. This case happened in 1999. The search of the vehicle happened in 1999. The inventory that you're referring to, Judge Cameron, happened in 1999. The first time the glove is mentioned anywhere on anything is in 2010. So yes, there's a picture of it. Where did that picture come from? Who took that picture? From where? When? Who knows?
What was the substance of the arguments made concerning the glove then in the post-trial motion for new trial and in the first appeal? What was the, again, I'm struggling with how this becomes new evidence when arguments related to the glove were raised long, long ago and resolved.
There could be lots of arguments that were made, and I didn't read the first appeal. I'll be completely honest with you. If I can brief that, I will. I mean, I skimmed through it 2 years ago when I started getting involved in the case.
Okay.
But once I saw the newly discovered evidence, that's kind of where we focused. We focused on
How is it newly discovered?
What's newly discovered is here. Let's break this down into pieces. Henry Ellis testified at the trial that there was nobody's DNA to test the glove against. Subsequently, we learned in 2018 that they did have two people's DNA to test the glove against.
That's a different argument, I think, but.
Well, that's the newly discovered evidence, and that's the relevance of it, and that's why it creates a big hole for the prosecutor. The question then becomes, why didn't they test the glove? If they really had it, and they had the DNA of a suspect, which they did, we know they did, that's documented. They had two suspects going way back to the early 2000s. In 1999, they had two suspects. They had their DNA within a couple of years, but they never tested the glove until 2010. And that begs the question, why not? So at trial, we were told from Henry Ellis, the reason that we never tested the glove is we didn't have a suspect's DNA to test it against. We learned in 2018 that's not true. The newly discovered evidence is these documents proving that the prosecutor did have the suspect's DNA on file and could have tested it, and they didn't. And the only plausible explanation is the glove wasn't
I
there.
find it wholly irrelevant. Honestly, I mean, when the testing was done, it matched your client.
But we're, okay.
Okay.
I understand what you're asking. Let me,
Yeah.
let me try to answer it. The glove matched my client's. That's true. If you were to test this suit, it would have my DNA on it.
Right.
If you then take a picture of the suit and say that at this date and time, it was committing a murder 100 miles away, that doesn't necessarily, you would have to show that the suit was there. So yes, the DNA is here. The DNA is on the glove. We know that. But how do you connect the glove to the murder? Why isn't the glove listed in any police reports from 1999 all the way until 2010? If there really was a glove in the car. If there really was a glove in the car, why wasn't it lab tested with everything else? By the way, this claim, the only part that's not newly discovered is this claim that he made, that the officer made, that he couldn't test the glove. He tested everything else that they found in the car, nail clippings and hair, and they sent it all for testing.
At the trial, the lack of any police report indicating that the glove was recovered from the vehicle would have been available for the trial attorney, defense attorney at that time, correct?
That's correct. That's not newly discovered. The fact that there's no police report that says that there was no glove, or that doesn't mention the glove, that's not newly
Classic
discovered.
cross-examination.
Right. The newly discovered, there's two pieces of newly discovered evidence. Number one is the FOIA documents from 2018, which prove that the police had two suspects' DNA to test. That's the newly discovered evidence, that there was DNA on profile of two suspects. We knew there were two suspects beforehand. We did not know they had their DNA. And that goes to the heart of what Officer Ellis's testimony was. The second piece of newly discovered evidence is Henry Ellis's affidavit and testimony, indicating that there's no plausible explanation for this other than we didn't have the DNA, which we know they did, or the glove didn't exist until 2010. It wasn't in, which means it wasn't in the back of the car. It wasn't there in 1999 when the police got there. We know this is from the July 22nd, 2015 transcript.
Let me just interrupt you for a second. Isn't there a third possibility that not identified by the detective is that there was a screw up by the Detroit Police Department that they didn't recognize and didn't want to admit?
Sure, but then that's a chain of custody problem, a major chain of custody problem. And why isn't it documented anywhere?
Their screw up?
No, the fact that there was a glove there. If this glove is going to be the only thing that connects this man to a life sentence.
We both agree that that was something that was known and subject to cross-examination at the time of trial.
Right.
Okay.
The issue that it wasn't in the right. What we did not have was proof that what the officer's testimony was at trial was untrue. Why didn't they test the glove? If it was there, if it was in fact there, all the way from 1999 to 2008 when it shows up, and then 2010 when it finally gets mentioned, why wasn't it tested all those years against Arthur Alley and Stewart? And what you're saying is a very good point, but the testimony of the officer himself is that based on his decades of experience and decades of being a police officer, this is not a situation where he works for me, by the way. This is a situation where he looked at what happened, read the entire file. We probably spent 3-4 hours together.
Right.
And then he was willing to sign an affidavit.
But I still don't think there's been a lot of investigation, for example, about screw ups with police officers. For example, rape kits in the Detroit Police Department lab. I still haven't, there's been a lot of people who have pointed fingers at each other, but nobody has acknowledged that, yep, I was the one who was responsible and I blew it. Instead, they're pointing the finger at, well, there's this possibility, it was someone else's responsibility.
Of course.
When I read this affidavit, it occurred to me that glaring possibility that the officer wasn't acknowledging. The most likely thing is that the officer in charge or whoever recovered the glove, somebody forgot to put it in a report, and because of that, it was never submitted to the lab. And then they're trying to reconcile the fact that they missed the issue by creating 2, not 3 possibilities.
Okay, so well, when you do sloppy work and follow it up with lies, that's what happens. There's another very important point that kind of is right around this topic, which is the July 22nd, 2015 transcript. There's a specific point where the officer actually says that while, and this is because he knew that there was a mess up, a big mess up, and had to come up with some sort of alibi, he actually testifies that they did not put the glove on evidence the day that they saw it. They brought it into storage, whatever that means, and then tagged it a day or two later, which makes no sense, follows no police protocol, and frankly, is just what it seems to me to be, is an officer just digging deep and trying to come up with something. And yeah, whether it was just a mess up that they followed up with lies or an actual planted piece of evidence or evidence that never existed.
Mr. Radner, isn't it true that the glove was listed in an evidence technician report dated March 8th of 1999?
No, not anything that I ever saw.
Okay.
If you're talking about what I think you're talking about, there's 2 pages to that report. The first page is dated 1999. The second page is dated 2010. The page that actually has the glove on it, which shows even more malfeasance by the police.
Okay.
Because people in 1999 might date something 1998, but they're not going to date it 2020 or 2010.
2010.
Yeah. If there's no other questions, then I guess I'll await with bated breath the order. I will just say in closing, you know, I've been doing innocence work now for about 10 years. In fact, the very first innocence case I ever had, I don't know if you remember, it was in front of Judge Cameron. You were on the panel.
Which one was that?
Bernard Young. And it was a bench trial with Judge Talbot, but this case is just has been screaming at me for 2 years that it needs a new trial. What happened to this man is unfair, and he's sitting in prison now.
There's overwhelming evidence of his guilt, in my opinion, but
there's a glove, only a
yeah.
glove, with a very questionable chain of custody.
Oh, come on now.
There's nothing else.
That's
There's nothing else.
okay. I think we've heard enough. You're a little heated. So it doesn't really help your cause, frankly. All right, case is submitted.
Did we have, I'm sorry, did we have prosecutions?
No,
Okay.
not endorsed.
Sorry, my team.
All right. Oh,
Yeah.
sorry.
Thank you.
Okay.
Oh, yeah.
With that, we are adjourned until 10 o'clock tomorrow morning. Thanks.